47 and 48. After latest will be engaged, I would like to file an additional affidavit. Can it be listed after vacation?
Heard Mr. A. Samoa, the learned counsel appearing on behalf of the petitioner. Petitioner,
Yes,
who's item number 50,
no, 70, 47 and 48.
appearing on behalf of the petitioner and submits that some time is required for the purpose of filing an affidavit in reply,
No, additional.
additional affidavit. Taking into account the above, lest the matter will be listed after the vacations.
Obliged.
May I please, your lordship? With the consent of other side, lordship, I beg to mention item number 55. Here, lordship, we are to file our affidavit, but due to inadvertent mistake from our side in name of the petitioner, we have requested some more time, lordship. Let it come after vacation, lordship.
If they take time, my lord, I pray for a date after vacation, my lord.
55.
Lordship.
At the request of the learned counsel for the government of Assam, matter stands adjourned to be listed again on 28th of July.
Lordship. Obliged.
Yes, Mr. P.
My lord, may I pray for my lord adjournment for the item number 10 to 22 series, my lord.
What is this?
This is
My lord, series matter of Gawura appointment, my lord. My lord, I have not feeling well, my lord, today.
10 to?
10 to 22 is a connected matter.
How are you? You are not there, Mr. B. There are a lot of other councils out there. Let us hear the other councils.
My lord, not like the matter.
No adjournment. Yes.
My lord, in respect of item number 65, my lord, I have made mention, my lord, for listing. It is listed when I pray for upgradation, my lord, it will be taken up.
55.
65, my lord.
Yes, what is this matter about?
The stipendary, my lord,
Oh, that one.
yes. I will request my.
We'll update.
Obliged.
What's item number 20 maybe adjourn, it will taken up after, lordship. Petition.
Huh?
Item number 28, lordship. Non-payment of pension due to not having the approval of the government in his regulation.
You want an adjournment?
So after petition.
Item number 28 after vacations.
Obliged.
Please, I beg to mention item number 61, my lord, for updated. Last,
Yes, why?
but on the last occasion, my lord, your lordship was allowed me to update this matter.
So, what is this matter about?
Matter is a pension, my lord. I am the first wife, my lord.
Oh, first wife, second wife. Okay, we'll take it up at 2.
Obliged.
61.
Okay, I please to mention the item number 29 here. The engaged counsel, T.K. Bhuyan, his mother died from Sunday, so he's not in Guwahati.
Okay. The request of the learned counsel for the petitioner. Matter stands adjourned. Up to be listed after 4 weeks.
Like,
Item number 1 for motion.
Why the matter is in motion?
Notice was issued already on, by the order dated 22/5. By this honorable court. So I think, my lord, wrongly has come up from.
I issued notice on 28.
Yes, my lord.
Yes, what is the stage? I fixed it today.
Yes, my lord. They were directed to file affidavit and get the
The
instruction.
claim of the petitioner herein is for the salary for the period from 1/1/2005 to 22/12/2014. Yes,
Well, BTC is the main respondents here, my lord.
BTC is not there.
No, my lord.
Oh,
Name given. Their name has not been reflected in the false list, my lord.
heard Mr. H.K. Das, the learned counsel appearing on behalf of the petitioner. Mr. N.J. Katoni appears on behalf of the respondent numbers 1, 2, and 4. Mr. R. Pujari appears for respondent number 3. None appears on behalf of the respondent number 5 and 6. It is relevant to take note of that on 22/5/2023, the This court had already issued notice, and as such, the matters ought to have been listed for admission. To list the matter again for admission after the summer vacations, thereby showing the name of Mr. S. Bora appearing on behalf of the respondent number 5 and 6.
How like that?
Deeply aware.
Anna two. Yes.
Method pertains to non-payment of retirement benefit, my lord. The petitioner was serving as a master worker, my lord. He joined on service on 1/6/1991, regularized with effect from 2005, my lord. And thereafter, he retired on service 30/11/2008, rendering total qualifying service of 70 years, 5 months, 29 days, my lord. And in Assam 108B, my lord, 10 years service is required for getting benefit, my lord. And on this reference, my lord, kindly see, my lord, page 61, this honorable court already passed, my lord, the similar situated person who rendered, my lord, 18 years service, my lord. Page 61, page annex of 10, my lord.
Yes, who is appearing for whom? PWD. You are appearing for madam?
I am appearing for 6, 7 and 8, your lordship, BTC.
You are BTC.
BTC.
You were not there in the earlier matter when the BTC was called.
Huh? That has been allotted to someone else, your lordship. Finance. Your lordship, name has not been reflected in the cause list.
We issue notice.
My lord.
But Mr. K.R. Padgiri, the learned counsel appearing on behalf of the petitioner. Mr. who is PWD, who is appearing?
PWD is P Nayak.
P.
P Nayak.
Nayak.
What?
P Nayak.
You are representing P. Nayak also?
Yes, your lordship. Both BTC and PWD.
You are BTC and PWD.
PWD. P Nayak.
Your name?
MS P Das.
P. Das. Miss P. Das appears on behalf of the respondent number 1, 4, 6,
6,
7,
7, 8.
8.
I'm for
Mr. Arbor Pujari appears for respondent number 3 and 9.
I'm for
And Mr. S.S. Roy appears for respondent number 2 and Miss appears for respondent number 5. Issue notice making it returnable on 14th of August 2023. As the respondents are duly represented, extra copies of the petition be served upon them by 30/6/2023. The case of the petitioner herein is that the petitioner have rendered. The petitioner was initially appointed on
1/6/1991.
1/6/1991 as a master roll worker under the office of the Assistant Executive Engineer, Kokrajhar Rural Road Subdivision, PWD, in the district of Kokrajhar, Assam. Subsequent thereto, on 22/7/2005, subsequent thereto, on the basis of an approval letter dated 30/9/2005, the services of the petitioner was regularized as grade 4 employee with effect from 22/7/2005. The petitioner retired on 30/11/2008. However, the petitioner have not been paid the pension for which the petitioner has initiated the instant petition. The learned counsel appearing on behalf of the petitioner has drawn the attention of the orders dated 10/5/2023, passed in WPC number 2538/2018, as well as the order dated 19/5/2023, passed in WPC number 2696/2023, and submitted that the petitioner herein case is duly covered by the said judgment. The learned counsel further has relied upon the office memorandum dated 18th of March 2020, 2010, of 31st of July 2010, and submitted that the earlier period of service has to be taken into account for the purpose of the pensionary benefit, for computation of the pensionary benefits of the petitioner. Taking into account the above, the respondents are therefore respondent BTC, you are the main person. Taking into account Ms. P. Das shall obtain the necessary instructions as to why the petitioner would not be entitled to the pension and pensionary benefits in terms with the provisions of the Assam Service Pension Rules 1969. I don't say,
May I please, your lordship, for PWD, your lordship, D Chaudhary name.
no, it doesn't keeps on changing as per your wish.
Give your views.
Well, the petition is eligible for suspension order, it is 22 to present 23.
What do you want? Suspension?
Suspension.
Why?
But it does a review, my lord, after 6 months, my lord, it has already been passed.
Huh?
6 months, my lord, has already been passed, my lord. This should make a review, my lord. On a person to an FI, my lord, I was arrested, man. On
You
7.
informed when? 12/5.
Madam.
Then whether 3 months is over after getting your bail.
My lord, I was getting bail on my lord, 2 to 2023.
Fantastic. But have you informed it?
But-
When?
But even I have filed in my lord,
No. We
Application.
only go as per documents. When did you inform? On paper.
my lord, I was, my lord,
Or should I render you to the civil court?
no, my lord,
Because that
suspension,
is the case of I say, you say. Tell me,
my lord,
when did you inform? 12/5.
my lord, suspension order was passed on.
I am not concerned with suspension order. When did you inform? 12/5.
12 by I have make a representative.
That you have been released on bail. When did you inform?
No, immediately I have been.
Where?
That was not the.
Then-
there. But I was suspended on 22 to 23, my lord.
Should I
Dismissed on 18 12.
Mr. Counsel, should I dismiss or you want an adjournment for 2 months? Not 2 months, yes. Till we fix it on 12/8. Which one? Either. I give you an option. Dismiss or withdraw with liberty to file again.
Man, wait, wait.
Heard Mr. A. Kondikar, the learned counsel appearing on behalf of the petitioner. Mr. D. Bora appears on behalf of the government of Assam. And Mr. R. Borpuzar appears for the finance department. Mr. D. Bora, the learned counsel appearing on behalf of the government of Assam had submitted that in view of the judgment of this court in the case of Rafid Ali Ahmed versus so-and-so reported in so-and-so, the petitioner, upon being released on bail, was required to inform the disciplinary authority that he had been released on bail. The learned counsel further submitted that from a perusal of Annexure F, it reveals that the petitioner had only informed on 12/5/2023. So taking into account the above, the learned counsel appearing on behalf of the petitioner submits that he may be permitted to withdraw the instant writ petition and given a liberty to refile if by within 3 months from the date of information so given by annexure F, the petitioner is either not reinstated or the memorandum of charge is not served upon him. Liberty as the petition stands closed on withdrawal, liberty as sought for is granted.
Declared.
Number 4.
Wait, your lordship. But this is application for against the suspension order matter. Pending departmental proceeding matter have been suspended on 31st of March matter with effect from 22nd of March matter. Page 31 is my impugned order matter. Page 31 matter.
Then
But given this matter, 3 months has been passed matter.
Huh?
But 3 months have been passed till today, no search sheet or charge application have been submitted to me matter.
Lordship, I came to know about the case only from my friend, Lordship. A copy has not been served to us, nor our name is there, Lordship.
who are you?
PWD, Lordship.
The PWD, there is a big problem now, finding out who is the counsel for PWD. Huh? That is why
No,
he must have submitted, given it to somebody.
Submitted.
Definitely he must have, otherwise the filing doesn't happen. And you,
but our
your
names are
counsels
also
keep
not
on changing.
reflected, Lordship.
Huh?
But our names are also not reflected in the court.
Heard Mr.
And more.
and Mohammed, the learned counsel appearing on behalf of the petitioner. Mr.
For one, Lordship.
Mr. B.
One and two.
Chaudhary appears on behalf of the respondent number 1,
1 and 2, Lordship.
1 and 2. Mr. Deborah appears for the respondent number 3, 4 and 5. Stop. Issue notice making it returnable on 17th of July, 2023. As the respondents are duly represented, extra copies of the petition be furnished to the learned counsels by 30/6/2023. The case of the petitioner herein is that the petitioner Mr. Counsel,
Madam,
what is your ground for filing this?
my ground is this matter, within this 3 month matter, they have not been served any matter. Search sheet which is required by law matter, search sheet or charge of allegation matter. I have stated in paragraph matter that is,
Understood. But when were you suspended?
yes, I am suspended matter 31st of March, with effect
So
from
3 months, when is it going to be over?
22nd of March,
Well, the impugned order is of 31st of March.
31st of March 2003. Yeah, that is the order, but we effect from matter 22nd of March.
Maybe, but
Yes.
that is the order of 31st of March.
Order 31st of March.
Then-
Effect is
When is the 3 months over?
3 months is over on when the effect was given to the matter from the death matter. 3 months of it past matter.
Have you submitted a representation?
Yes, matter, I have submitted matter.
When?
My lord, I have submitted before I admitted some matter.
Where?
Page matter, page 32. For his statement matter.
When?
That matter 17.5.
Then? What? 17.5, 12.5.
Yeah. Page 32 matter.
That is what I have seen it. Then go there. You file a representation, say that all these things. Ajay Chaudhary within 3 months.
I have-
And otherwise, if it is not there, then you can come over. You can't come, as of
No,
now, you
filed-
don't have the cause of action.
In May, matter, I have filed it, but the matter, the matter has been disposed of today, matter, nothing of the sort has come to me, matter.
Obviously, the
But
3 months will be over on
just one,
30th of March,
one, my,
or
one, my,
1st of July.
one problem is, matter, I am going to retire on matter September of this month. That is a problem, matter.
I can't help it. You ask, go before the Supreme Court, ask the Ajay Chaudhary to be changed. I can't help it. Your 3 months is not over.
But we will also see the effect from the date of effect, my lord, 22nd of March. That is, my lord. Effect is, your lordship, see the, page 31, my lord. It is written here, my lord. Page 31, my lord, with effect from 2nd of March. 90 days gone, my lord. It will count, my lord, from the date of, my lord, from the date of, it come to effect. Effective 2nd of March, my lord. I am not wrong, my lord.
When were you were arrested?
My lord, I have page 12, madam, I have given my lord, the petitioner submit that, and till today no charge of allegation have been submitted to me by the department.
You were arrested.
Arrested,
You were released on 28/4.
26/4.
28/4, page 30. Then
I have been arrested and the honor when I was in jail, my lord, yes, sir, my copy, my lord.
28/4, you were released.
My lord,
Then where's your case?
the order, they themselves said, my lord. this
Mr.
order
Mr.
comes
Mo-
from Senate second. Was
Mr.
that wrong, my lord?
Mohammed, you were already must have heard there was another matter of Mr. Khanikar.
My
You
lord,
want the liberty to withdraw because you have not completed 3 months. You were arrested, you were released on 28/3.
What is the
Your
meaning
period
of
does
effect,
not
my lord?
start.
My lord, your lordship, see, what is the meaning of which effect from, my lord? That is what is the meaning?
Whatever may be,
What is the meaning?
this with effect form has been given in view of the deeming provision which is there in the proviso to Rule 6.
I find no difference between my effect of my effect is coming. When it comes to effect, my lord, any
Okay.
order comes to effect, that will count as.
Fantastic.
Order may pass, my lord,
You,
must have. My lord.
Mr. Mohammed,
Yeah.
you want to withdraw or dismiss? Which one? Which one do you?
My lord, may I know, my lord, what to be done, my lord?
You withdraw and file your representation after this because 3 months is not over. Let the 3 months be over, then only you can accrue a right for the getting a reinstatement.
My lord, may pay, lord, my lord, this petition may be kept pending, but in the meantime, I will be allowed to submit.
We have already submitted on 12/5. So we fix it on 12/8.
My lord,
12/8.
my
This
lord,
the matter, issue notice
11.
12/8.
Representation, the filing of representation cannot be counted. 3 months is not counted from the date of filing representation, my lord.
That is,
Or my lord,
the law is settled. I can't help you on that.
that means your lordship saying, my lord, that from the date of filing representation, that should be 3 months.
If the moment you are outside, you have to bring it to the notice of these authorities. They look here, I am out. When did you bring it?
Why they have filed, my lord, subset order to me, where I was in jail, my lord. What is wrong? They are wrong, my lord.
Oh, Mr. Mohammed, why don't you go and fight an election and get the rules changed?
I am simply saying, my lord. They know
What do you want?
My-
Should
my-
I dismiss or fix the matter after
That is
3
even,
months?
my lord.
Which one?
My lord,
Which one do you want?
that may I know, my lord.
No, nothing more than that.
I-
I will do one thing. If necessary, I will give a lecture out there somewhere else. But for the time being,
What
we are before vacation.
I will do it, as per your lordship order, I will do it. Only I know it, my lord. Your lordship asking that 3 months is prepared from the date of representation. That is done, my lord.
No, from the date you inform the authority, they look here, I am outside. I have been released on bail. Then only they get a chance.
That means, yes, I have filed an application before 12th of May. That from that day, 3 months. will be
3
done.
months.
Yes, I am agree, my lord.
Yeah.
Yes, I am allowed to do it, my lord. I will file it.
Yeah, that is better.
After our 3 months, my lord.
Yeah.
Yes.
এই আগৰ অৰ্ডাৰটো যোনটো আছিল নাম চেঞ্জ নাম কেইটা এইটো একে হ'ব খালি will file it after 12/8.
That one thing is what I am going to.
He has been released on 28/4
26.
and he has submitted a representation on 12/5. এইটো আগতে ডি বৰাই সাবমিট কৰিছে এইটো মিস্টাৰ বি চৌধুৰীয়ে সাবমিট withdraw. Yes, Mr. Badgi.
Yes, my lord, the petitioner husband was serving as a master roll worker, my lord. He joined in service 16/10/81, and subsequently he died on 2/12.
Finalize the death benefits and arrear and current monthly family pension in favor of the petitioner.
My lord,
Whether your husband was getting the pension?
no, my lord, he died during the course of service, my lord,
Oh, master roll.
master roll. And he is serving 23 years, 1 month, 16 days, my lord.
Similar to item number 2, Lordship has issued notice of motion there.
No, it is not similar because that person is alive.
Alive.
No, here,
This person, he's asking for what?
family pension.
He died prior to regulation of his service, my lord.
No, here it will be different because here, whether he has been regularized here,
Regular, subsequently regular.
Subsequently regularized,
when?
My lord, with effect from my lord, kindly see, my lord.
22/7/2005.
And you work till?
Till my lord, date, my lord, 2/12/2004.
Why are you approaching this court now?
My lord,
Why?
except point to my lord, stating that my lord, he died prior to regulation, he is not entitled pension, my lord.
Understood. But why are you approaching now?
But the department authority advised the my lord petitioner, my lord.
Oh,
That
now the
he is not
department also
entitled.
gives solicits advice.
And
Lordship, this is the
subsequently, my lord,
synopsis second para. Recently, the statement has been made. Recently, the petitioner came to the synopsis. That is second para.
And
They are
Yes,
relying on your
roughly.
lordship's one of the judgments of your lordship.
recently, the petitioner has come to a similar order of so and so was the departure order. And they demand whereby directed to release and after knowing the petitioner submitted. Which order you are referring to?
page 29, my lord, annexure C. Order dated 31/2023.
Text and then negative.
This case, my lord,
Readings
the
complete with. Readings complete.
petitioner retired, my lord, prior to regulation.
So with a judgment being delivered now,
And subsequently, I filed.
there was a
petition.
case of, that case was pertaining to 19 years, 11 months.
My lord,
And therefore he did not have 20 years. And 1 month was the there and as such this court directed under 67 to do that.
my lord.
Then
And my lord, in this case, the petitioner, the husband of the petitioner serving 23 years. As per my lord, office member, 20 years of service is required for getting pension, my lord. But my lord refused to getting their pension because of that, my lord, he died prior to regulation.
understood, but why are you approaching now because of a judgment?
And certainly I.
Then why not all the cases be reopened? That person you approached immediately.
Is a my lord, pension is a my lord, continuous process, my lord. With the
It is not a continuous process. Why didn't you approach then? How do you explain that you have not approached from 2000 for the last 18 years, 19 years?
19.
Then because this is not a case which will come out there.
This is notice maybe is the.
It would be 5/10/2005 would be there. He took a negative. Yeah. I would declare.
Yes, Mr. Babujari, what is there?
She will have to perhaps my lord issue notice of motion because question of facts are involved here. The lordship will see, my lord, that
The husband of the petitioner, he died on my lord 2/12/2004.
That is what,
Yes, and my lord, it appears, my lord, from the record that my lord will find at page 23 of the writ petition that his services was regularized, my lord, after his death. So perhaps, my lord, here the administrative department will have to file an affidavit.
no, I'm not on that. That is not a problem. But how do you take care of 140? Here we are concerned with family pension. That too, otherwise that can be taken care of. Because if he has 23 years and he was regularized, but with the regularization being done after his death also, can there be a regularization after the death?
Perhaps, my lord, the administrative department will be.
They do a lot of things. They have done many things.
My lord.
So if they have regularized after the death,
For the
maybe the
purpose-
process must have been initiated
Yes,
earlier.
Yes. This regularization, my lord, is the in-person and regularization only to give the benefit, my lord, of pension to the deceased master roll worker. Normally happens, my lord, the departments.
No, there are many cases where only one day that
One
is
day,
done.
one day, my lord.
And in fact, why Uday Pratap Thakur, that judgment which I have applied in this
Yes,
case,
yes,
this has to be in conjunction with that office memorandum which I got it that day,
yes,
31/7/2010.
Yes.
Both of them has to be read and thereby granting him only to so much of the benefit to that extent.
yes. Now benchmark is 20 years. Now 20 years.
Now,
my-
20 years is for not confirmed.
now 20 years.
But-
Yes,
But if a person is confirmed
yes.
or regularized, but he is regularized for only one day,
That that is the, my lord, reason, if a person completes 20 years, the state, my lord, being a welfare state, finds that he has already completed 20 years. He has even, my lord, gone beyond 20 years. I mean, he ought to have been regularized. If he is regularized, his quantum of pension will differ. He will get some more benefit. If that exercise is undertaken, keeping in mind.
no,
my
no,
lord,
there is a big problem of that. How are you doing for the 20 years people? You are calculating 20 years.
20 years, my lord, there is an.
To unconfirmed service, you are giving 20 years.
20 years, my lord.
And but my judgment out here says, following Uday Pratap saying, that then if a person is regularized,
Yes,
only so much should be given only for the purpose of getting him the pension under 108.
yes,
So that 10 years will be only taken.
yes, 10 years will be taken.
But why you are giving for 20 years for people who have not yet been regularized?
So there is a OM, my lord. I do not have it right now, my lord. I beg apology for that. There is a OM, lordship has gone- gone through it, my lord.
2003, my lord.
Lordship,
6 September
lordship,
2003.
That is that he will be entitled to pension.
yes,
It does not say what will be the qualifying years.
yes.
How many years? It doesn't say.
It is only one continuous service.
No, if a person has continuous service of 20 years, he will be entitled to pension. That is this OMC.
Yes,
But how much will be taken has not been taken. Now, if a person is regularized and is being given benefit in view of the Supreme Court judgment and that 31/7/2010 office memorandum, he gets only 10 years is taken because the qualifying service is 10 years, because once he's regularized, it's 10 years.
yes. Even if he gets for 10 years, his quantum will be more because once he is regularized, his pay scale will differ, my lord. Remuneration will differ. Remuneration will increase. Because master roll workers normally, my lord, they have, my lord, paid fixed amounts randomly this and that. Different departments adopt different parameters. Of course, after my lord, the post stupendous, everything has now been streamlined.
Now, in this case,
Yes,
he has 23 years. So by dint of that office memorandum, he'll be entitled to pension.
that's what.
That is okay.
Yes,
But how do you bring him within the ambit of family pension?
the family pension, my lord, 140.
Although I have dealt with in this judgment, which Mr. Patgeri has got it, it was a very difficult thing. I had with great difficulty, I have stated this, and you have not challenged this thing in the division bench, which makes again the problem. Kindly come to page 37 of the paragraph 16. This is how I have dealt with 140. The next claim which arises is as regards the family pension to the petitioner with effect from 29/5/2005 onwards. At this stage, this court finds it relevant to take note of Rule 140 of the rules. The said provision is quoted. A perusal of the above rules show that except as otherwise provided in Rule 142, a family pension not exceeding the rate mentioned in Rule 141 will be admissible in case of a death of an officer while in service or after retirement on or after 1/1/1964. If at the time of the death, the retired officer was in receipt of compensation, invalid, retiring, or superannuation. In case of a death while in service, it is the mandate that the government servant should have completed minimum 1 year of service. Note 1 appended to the said rule explains the term 1 year of service mentioned in the rule not to include broken periods of service, and the service for the period should be in continuous. In terms in note 2, for the purpose of computing the minimum period of completed 1 year of continuous boy service and periods of extraordinary, if any, shall be excluded. Therefore, it will be seen that an officer while in service on or after year, if at the time of the death was in receipt of a compensation, invalid, retiring, family pension is to be payable. The question of having completed minimum of 1 year of service would arise only in the case of a death while in service. Get the point?
Yes.
Now, in your case, did you die while in service? Then how do you get 140? If you are already getting the compensation, then automatically you will get it. If you are entitled to getting a pension, because in this case, the person ought to have got the pension, but he was deprived of that. But in your case, the person died while in service. Then how do you get the benefit under the family pension? That is the difference.
Yes.
Anyways, we will hear it some other day. Why should I dismiss before we're in the vacation? Heard Mr. K.R. Padgiri, the learned counsel, appearing on behalf of the petitioner. But you file an additional affidavit. Mr. R. Bapujari appears on behalf of
My lord, respondent 3 and 7, my lord.
3 and 7. Mr. Ardhar appears on behalf of the Sericulture Department. 1, 4 and 6. Mr.
CS Hazarika for respond number 2.
So and so for and Miss so and so for respondent number 5. Okay. Issue notice making returnable by 18th is closed by 21st of July, August 2023. As the respondents are duly represented, extra copies of the petition be served upon them during the course of the hearing by 30/6/2023. The case of the petitioner hearing is that the petitioner, the husband of the petitioner, was engaged as a master role worker in Eri Concentration Center, Kabikara, under the Assistant Director of Sericulture, Darong, Mongoldoi, on 16/10/1981. And during the course of his service, on 2/12/2004, he expired, leaving behind the petitioner and his one son and one daughter. Further to that, the services of the petitioner, husband of the petitioner, was subsequently regularized after his death by an order dated 5/10/2005 with effect from 22/7/2005. The instant writ petition has been filed claiming that the petitioner is entitled to the arrear pension, is entitled to the family pension with effect from the death of the husband of the petitioner. The respondents are therefore, the respondents are directed to obtain instructions in that regard. The learned counsel for the petitioner shall also file an affidavit explaining as to why the instant writ petition has been filed after a delay of 18 years. The question of delay and laches is kept open.
Right.
That is, Mr. Barbujari, you have to look into that,
Yes, yes.
because while in service he had died, so how can he get the benefit?
That decision of my lord is not applicable here.
Ah.
He is seeking, my lord,
Exactly, my
he is
And that delay maybe, my lord, he was waiting for this petition also waiting for this. For the last 18 years. My lord, sorry.
Your submission reminds me of a recent Netflix series Scoop, where the argument which was made by the lawyer was about this person knew that this person will be there waiting out there at that particular point of time.
In case of family pension, my lord, Form 9, my lord, the department has to inform, my lord, for submitting the pension papers, my lord. That work has not done, my lord.
When did that start?
Problem.
Yes. Yes, Mr. Chaudhary.
Yes,
Hello, 6.
my lord, we are praying for changeover from CPF to GPF. My lord, in terms of that notification, where in fact, my lord, there is a judgment of the Supreme Court, my lord, we have extracted that passage at page 38. This is 2022 SCC online 594. Para 3. According to the notification dated 1/5/87, employee joining the service after 1/1/86 would always be under GPF. With respect to those who are in service on 1/1/86, said employee would be deemed to have come over to GPF unless an option to continue to be under CPF was consciously exercised before the cutoff date. Thus, when the scheme was framed and was sought to be implemented, the concerned authorities must have been taken into account the entire magnitude, such as the number of employees and the.
You are referring to which page?
Well, page 38.
Ah.
The para 35 of the judgment is quoted. According to the notification dated 1/5/87, employee joining the service after 1/1/86 would always be under GPF. With respect to those who were in service on 1/1/86, said employee would be deemed to have come over to GPF unless an option to continue to be under CPF was consciously exercised before the cutoff date. Cutoff date was, my lord, 39/87. Thus, when this scheme was framed and was sought to be implemented, concerned authorities must have taken into account the entire magnitude, such as the number of employees and the likelihood of the impact on the management of the fund, so that reasonable return can be effected by your pension upon retirement of such person. Going by the intent of the notification, those who were to opt for CPF were an exception, and the general rule was everybody after 1/1/86 would normally be covered by GPF.
Now you want to come to CPF, GPF.
GPF. Well, as per that notification, those who were on 1/1/86, they had an option to continue with CPF, provided that, my lord, they are required to exercise an option. Otherwise, my lord, by legal fiction, they've already
GPF.
GPF. I think, my lord, they would like to have their efforts, I file their affidavit.
Mr. Ken Shonri, the learned senior counsel, assisted by Mr. A. Das. Mr. R.P. Kapoti, appearing on behalf of the respondent number
2, 3, 5, and 6, Lordship.
2, 3, 5, and 6.
Lordship.
AB.
Mr. A.B. Day.
Huh?
AB Day, my lord.
Mr. A.B. Day.
Who appears for this, two,
One and
one and, one and four,
Logic, no,
one and four?
Central government comes.
Where is the central government? We saw SS Roy somewhere nearby. Mr. SS Roy appears on behalf of the respondent number 1 and 4. As a issue notice making it returnable, how much time you will require for filing affidavit?
4 weeks time, Lordship.
Okay. Issue notice making it returnable on 21st of August 2023.
Lord.
As the respondents are duly represented, the extra copies of the writ petition be served upon the learned counsels representing the respondents on or before 30/6/2023. The case of the petitioners herein is that the petitioner that the petitioners are employees, former employees of Indian Institute of Technology, Guwahati.
I don't know.
Did you join service before 86 or after?
After it, it's
The petitioners joined the services after 1186. Referring to the judgment of the Supreme Court in the case of University of Delhi versus Shashi Kiran and others reported in 2022 SCC Online SC 594. The learned senior counsel had submitted that in terms of the notification dated 1/5/1987, the employee joining the services after 1/1/1986 would always be under the General Provident Fund.
yes.
It is only those employees who joined prior to 1/1/1986 who had the option of.
Prior or on that date.
It is only those persons, those employees who have joined prior or on 1/1/1986 who had the option of either continuing with the CPF, Contributory Pension Provident Fund, or GPF. As the petitioners herein had joined after 1/1/1986, the petitioners are therefore within the services of the petitioner came under the GPF. The respondent authorities, however, have refused to grant the benefit of the GPF to the petitioner for which the instant writ petition has been filed. The respondents are therefore directed to file their affidavit on or before 14th of August 2023 The petitioner thereupon shall be at liberty to file their reply if so advised.
Oblige.
66.
Whole senior counsel, article senior counsel, it's assisted by.
May I please, Your Lordship? My lord,
Yes, Mr. Monto.
my lord, this matter relates to my lord, the claiming the UGC scale by the petitioner from the date of his initial appointment, not from the date of
Claiming
the initial date of appointment, that is of 8/7/1994. Instead of my lord, that is on
directly responsible to give the benefits of UGC scale of pay with increment to the petitioner from the date of his appointment as lecturer in political science with effect from Iman instead of Iman by refixing so and so by removing or rectifying.
Wait, higher
each
photo?
one of them.
So move under the Utilization higher to.
Who appears for higher education? No higher education nowadays.
Milord, may kindly come to page 35. I am appearing for the UGC, Milord.
Yes.
Is the page 35 is the certificate of MPhil.
this is not the issue, my lord.
Hmm.
That is the issue, Milord.
Hmm.
He has to, this person has to return all the benefits.
Hmm?
This person has to return all the benefits. If this certificate is proved to be obtained, this MPhil degree is proved to be obtained from off-campus study center. He is not entitled to UGC benefits, my lord.
I'll come on that, my lord. Off campus is closed from the 2009. Prior to that, my lord, the off campus was.
That he has to prove that it was not
But my
off-campus.
case is not there, my
My
lord.
lord,
Mr. Songwa, you have a mic. I can hear. We have removed the glass.
sorry, my lord, sorry,
So don't keep your voice down.
sorry.
Yes.
But my respectful submission is, my lord.
Yeah.
He was, in 1993, he was appointed by the governing body without UGC scale of pay. Then option was given to him that you obtain the UGC norms, qualification, MPhil like that, then he will be given the UGC scale of pay. He obtained this degree through distance mode. It is written as a distance mode, Directorate of Distance Mode. Only because that he obtained this degree in 2007, that is why it is acceptable. But it is acceptable if the examination center was in the university itself, not in the off-campus. If he produces the admit card of
That
this,
matter you were arguing there in the division bench also, no? That Pragjutis, what is that? There's another college which was there, no? Oh, Pondicherry University.
yeah, Pondicherry, same thing, this is the same thing.
Ah.
If they have, if they can.
But in that Pondicherry University, you have supported the Pondicherry
No.
University. Yes,
No, not supported.
yes, yes.
No,
you have
but
supported
I
that.
clearly,
I remember that.
that's a global open university, not Pondicherry University.
No, that one, Pondicherry University, you have stated out there that yes, it is okay, but the court said that as it was held out there at Pandu, and as such, it could not have been that.
That was my, on affidavit, I said,
Ah,
that was not my verbal submission.
so,
The degree is okay.
ah,
Distance education, they can provide a degree to a non-technical post, technical degree through distance education. But the examination has to be held in that university itself, not in any other place. In that particular case, it was Ashit Baranpal. The case was, that particular person appeared in the examination Pandu College.
yes, I remember that.
Yes, and that is why I say that if it is, since it is appeared in the Pandu College, examination center was in Pandu College, it's not a valid degree. I was on affidavit, not on the oral submission. On affidavit, I submitted. I can produce the judgment even.
No, that was the submission of the what you are submitting, that was the submission of the higher education department.
But I submit,
Saying that, first of all, this distance couldn't have been done because of the fact that this examination was held out there at Pandu and the territorial jurisdiction of that university was only within Pondicherry.
only we did Pondicherry. Now, my lord, it has been more restricted that they cannot have the examination even outside the campus of the university. They have to have the examination center within the campus of the university.
Understood, but that matter is pending before the division bench, so I think this is a fit case for issuance for notice.
Yes, notice I am not objecting. Then next year, Lordship will see, this is a matter of 1994, he is claiming in the year 2023. That I leave it to you, Lord. I just pointed out.
It is only for my lord, this, whatever is found, learned friend is saying, my lord, that the MPhil, but my case is that my lord, the MPhil, whatever was I obtained, my lord, that is, my lord, the unnecessary I was forced to obtain. But the facts is that the day of the appointment and the regular, my service was, my lord, the approved by the PSC, this condition is not necessary, my lord, because the simply UGC's, my lord, qualification was that 55% marks in the master degree.
Oh, Mr.
So
Sama,
this is the case, my lord.
I have dealt with similar matters, no?
Yes,
You
my
remember
lord.
that matter? There were two matters where you have appeared also. I
No.
disposed of that. You have to have that 55%.
Yes, my lord, this is.
Not, that was the specific case. You were there.
No.
Mr.
And
KK.
similarly,
Post of marks
my
with it.
lord, it is
You
already
remember
removed.
that matter? It was before this court. There were two. One was of which college? Hemaji or
Well,
somewhere.
this is a cyclostyle, my lord, type of my lord, appointment letter. So that was a mistake on the part of the
Well-
PSC. That was removed.
There was the director of higher education, the principal had granted the benefit of UGC scale. And pursuant to that, this matter, the director of higher education had issued notice to the principal also. And directed that why have you given? And his specific case was that I had 55% and so and so. But if you see the 98 regulation, it says to have a particular MPhil or something to that effect.
Yes.
This is only for the underqualified. Those who are not having the MP number 55 marks.
Yeah.
Yes, I
It is
will
only for
collect
that.
the judgment.
Yeah.
Right now, I am not recalling.
Yes.
Well, I have to check one more thing. What was the
Then why haven't you, Mr. Monto, why didn't you challenge all this while? Hey, to Guri Bhai Chidi.
No, my lord, I am not challenging anything, my lord, because the condition, my lord, that is
Good
imposed,
batch.
that is condition imposed
Brought
in
up
one and two, that is not applicable to me. That is why I already filed a representation earlier also. That was not considered.
When did you submit your representation?
Another one, that was filed in 2019, while my fixation of the salary was done in a wrong manner. And now this subsequently was in 2023 also.
But you got the pay scale only from 2008.
So I said,
Then what were you doing from 2008?
well, I mentioned.
Or why didn't you even ask that why should I have a MPhil degree? From 1998, I should be giving it.
No, my lord, the MPhil degree, that's, I was compelled to do that time, but that is why I.
Understood, but compel or whatever, why didn't you ask for that scale, UGC pay scale then?
Because, well,
Because if I remember correctly, the director of higher education is very clear that you have to have the UGC norms
No, my lord, yes, this is.
for a
clear, my lord.
lecturer.
This is a para 17, I have specifically mentioned, my lord.
Hmm?
At the para 17, my petition, I have specifically mentioned. At
Hmm.
that time, there was a, my lord, process of cyclostyle, my lord, copy of the.
Where's the regulation? You are entire
Well, one-
regulation at that relevant point of time.
One copy I was.
Only for 1 year or something, there was some confusion. Then at that point of time, it was not insisted upon.
Yes, yes.
Yes.
That I will clarify, my lord. I have that regulations. but right
Anyways,
now
we
I-
issue notice,
One document I
Mr. P. Mohanto, the learned counsel appearing on behalf of the petitioner, Mr. A. Samua appears on behalf of the respondent number three. Mr. K. A. D. Upamanyu appears for respondent number 1, 2, 4,
No, Lordship, only one.
one and 2.
4 and 5 would notice.
Put by register post, my lord.
Issue notice making it returnable
Accept.
on 23rd of August 2023. As the respondent number 1, 2, and 3 are duly represented, extra copies of the petition be served upon them by 36/2023. As regards the respondent number 4 and 5, steps be taken by way of registered as well as usual by 26/2023. So the case of the petitioner herein is that the petitioner was initially appointed in the year
94.
92.
1992 as a lecturer in the Department of Political Science in MK College. MK College, na?
Yes, my.
MK College, Singa. Thereupon, when is the confirmation? Director?
This is what a 94,
Ah,
87.
Thereupon, the Joint Director of Higher Education, by an order dated 8/7/1994 confirmed
Next up, three. At page 29.
approved the appointment of the petitioner by the order dated 8/7/1994. Full stop. In the said order, it was mentioned as serial number 1 that the petitioner would be entitled to enjoy the increment benefits in the UGC scale of pay after obtaining MPhil or PhD degree within 8 years, failing which the service will not continue. Full stop. The petitioner thereupon obtained the MPhil degree on
2008, my lord.
2008,
Next up, 7, my.
as can be seen from Annexure 5. Why you are enclosing a provisional certificate, not the final one? Huh?
My lord. This is my lord.
As could be seen from Annexure 5, which is a provisional certificate of MPhil in political science issued by the Vinayaka Mission University.
94 8 years.
Full stop. The petitioner now, by way of the instant writ petition, have challenged clause 1 of the order dated 8/7/1994. Full stop. The learned counsel, appearing on behalf of the UGC as well as for the higher education, have objected to the instant petition on the ground that the writ petition suffers from delay and laches. On merits also, the writ petition has been opposed. Be that as it may, this court is of the opinion that it would be in the interest of justice that an opportunity that the said objections of the respondents be brought on record by way of filing affidavits. List the matter again on date to this one. Affidavit. What is the date I have given? 23rd, no?
23rd of July.
No, August.
August, sorry.
Affidavit. Under such circumstances, the UGC, the respondent numbers 1, 2, and 3 are therefore directed to file their affidavits by 14th of August. Full stop. The maintainability of the writ petition on the ground of delay or laches, is kept open.
My lord, may I pray, my lord? My learned friend should bring the admit card of this Annexure 5 document.
You can very well say whatever you like in your affidavit. If he doesn't bring the admit card also, how does it matter? He's only asking for, you have already given on the basis of the MPhil. Earlier to that, he's asking. Your only thing is either, how can you challenge in 1994? And prior to that, if there was no MPhil degree, he had to have the MPhil degree. That is your stand as per
Yes,
the UGC. Let's see on that. We are not concerned after that.
My claim is that the plea is
I'm coming in 5 minutes.
Please, your lordship.
Yes.
Lordship, this petitioner joined as master roll worker, lordship, on 1986, lordship. Thereafter, he is appointed as work charge, lordship. Thereafter, lordship, his service was terminated, and lordship, subsequently petitioner filed a civil rule before this honorable court, lordship. And this honorable court, Lordship White, order dated 91/1/93, Lordship, please come to page number 20, Lordship.
Yes,
Lordship, page number 21, Lordship, where the direction was there, Lordship. This writ petition is disposed in terms of the following order. The state government of the Assam is verified the vacancy position of the category of daily laborers, casual laborers, master workers in Karbi Anglong division, Lordship, and frame a scheme in fair and just manner for regularization of the 18 petitioners, Lordship. The petitioner is one of the petitioner here, Lordship. And petitioner name above having regard to their length of service and other relevant conditions, including the prescribed qualification, if any. While observing the petitions on regular basis, age bar shall be waived, and the reservation rule shall be complied with. The scheme shall be framed within 6 months from today, Lordship. But Lordship, subsequently, communication was going on between the respondent authority, Lordship, and 31/12/22, the petitioner retired, Lordship. Thereafter, petitioner submitted his relevant documents for pension papers, Lordship, but
you were working on else,
Lordship,
you were working else
work charge, Lordship, section assistant,
under
under Irrigation Department, Lordship,
of
Karbi Anglong, Lordship, Irrigation Department.
then
Then Lordship, 18/5/23, Lordship, my pension paper has been returned, Lordship, finally page number 68, Lordship. Return the pension paper in respect of this Sri Narayan Chandra Bora, Lordship, work charge section. With reference to above, I am returned where with the pension proposal along with the supporting particulars in respect of the above mentioned retired employee, as his service was not regularized. The work charge person is not entitled to get pensionary benefit except terminal gratuity as per Assam Service Rules, Lordship. Now here I have come to know, Lordship, my service has not been regularized, and now I have not received anything, Lordship. No pensionary benefit, nothing, Lordship. Provisional pension I have not received, Lordship.
yes, madam. Very well. But madam, you are asking for twofold reliefs. One is for setting aside debt. That we'll look into. Second is for regularization,
Yes, Lordship.
which is not possible. Third is for pension paper, for taking into account the length of service. That can be considered, but not for regularization. Regularization, that order is there, but how do you take care of Uma Devi? This court can direct. Can it?
Lordship, but the communication was going on, proposals are.
Understood, but can this court direct? Unless Uma Devi has been overruled.
Service is dangerous. I have been here, Lordship, for more than 30 years. Lordship.
So on that 30 years, we'll look into it. Third, Miss M. Nirola, the learned counsel appearing on behalf of the petitioner. Miss, who appears for whom? Irrigation, madam? So and so appears on behalf of the respondent number 1, 3, and 6. Miss, your name?
Lordship, as can pray, I am for 2 and 6, Lordship. No,
2
I'll be
and
for 1 and 3.
2 and
6, Lordship.
6. Take it here. No, it appears for 1 and 4
1 and 3.
and 3. Mr. Arke Talukde appears for respondent number 5. So and so appears for respondent number 4. So, issue notice making it returnable on 16th of August 2023. As the respondents are duly represented, extra copies of the petition be served by 30/6/2023. The case of the petitioner herein is that the petitioner was initially appointed as a work charge section assistant in the Department of Irrigation under the Dipu subdivision of Karbi Anglong on 21/5/1991. However, his service was thereupon terminated on 24/9/1991. The petitioner thereupon challenged the said order before this court in WPC number in Civil Rule number 4919/1991. And this court, by an order dated 29/1/1993, allowed the said petition and directed the respondent authorities to verify the vacancy position of the category of daily laborers, casual laborers, master roll workers in the Karbi Anglong Division Irrigation Department, Irrigation, and frame a scheme in a fair and just manner for regularization of the petitioner along with 17 persons, having regard to their length of service and other relevant conditions, including prescribed qualifications, if any, and while absorbing the petitioner on regular basis, age bars shall be waived and reservation rules shall be complied with, and further directed to frame the scheme within 6 months from the day of the order. The petitioner thereupon was again appointed as the work charge section assistant on 27/7/1993. The petitioner continued to render his service and retired on 30/11/2022. 31/12/2022. It is the case of the petitioner that the petitioner have rendered more than 30 years of service as a work charge assistant. And as such, the petitioner would be entitled to pension and other pensionary benefits. In terms with the office memorandum dated 6th of September 2003, issued by the Secretary to the Government of Assam Pension and Public Grievances Department. The respondent authorities are therefore directed to obtain instructions as to why the petitioner herein would not be entitled to pension and other pensionary benefits in terms with the said office memorandum.
Lordship, petitioner has not been receiving provisional other benefit also.
Then that is too much to ask.
Order stay vacating item number 7.
Yes.
Well, this IA is for modification of the honorable court order. Dated 17/5/2023. Lordship, may kindly come to page, it starts at page 11, kindly come to page 12. In fact, while issuing notice, kindly see, after careful reading of the impugned order dated 9/5/2013, this court is of the prima facie opinion that the impugned order is punitive in nature. Therefore, the petitioner has made out a strong prima facie case in her favor, calling for interference by this court. And finally, having regard to the facts and circumstances of the case, the operation of the impugned transfer order dated 9/5/23 is hereby stayed. Consequently, the petitioner shall be allowed to work as supervisor at Karunabari ICDS project until further order. Now, we have a difficulty with this particular transfer order we have annexed. Kindly come to page 18. By this order,
yes,
copy has been marked to at serial number 3. It has been marked to the Joint Director, Women, Child and Child Development Branch Officer, Establishment Branch. She is directed to initiate departmental proceeding against Srimati Korbi Borua, Supervisor so and so, for violation of official discipline and decorum and insubordination to higher authority as per provisions of Assam Services Discipline and Appeal Rules 1964. By the same order,
you have no problem with the transfer being stayed, but you have a problem by
with the
this direction.
departmental proceeding.
That's all.
Yes, that's all. Kindly come to para 7 of our.
No.
Well, the
Anything more?
transfer order itself says, my lord, that
Whatever may be, transfer order has been stayed.
Yes, my lord.
Departmental proceedings you are with, this court has not stated.
No, that's what I am
So
submitting. my
let
lord.
them initiate departmental proceeding against you.
In fact, my lord,
But my lord, director, by this order itself, it reflects. My lord, I'll kindly turn to page number 16 of this IA in para 2 of the impugned order, paragraph 2. I read, my lord. It has appeared that the reply submitted by Mrs. Srimati Karabi Borua is not satisfactory. Second paragraph towards the last.
Para?
Page 16, second paragraph. Towards the last, my lord. It has appeared that the reply submitted by Srimati Karabi Borua is not satisfactory. Has your lordship got it, my lord? Is not satisfactory. The alleged act of Srimati Borua amounts to insubordination to higher authority and violation of official discipline and decorum. My lord, if this is there, my lord, then there is already a decision taken by the authority, my lord, by director, that and that is why, my lord, this transfer was punitive, my lord. Man, again, they are going to. That is what I want to submit, my lord. There again, moment the authority has come to a conclusion that I have committed the act of alleged act, my lord. Now they again want to initiate departmental proceeding. That is what, my lord.
On what basis was this order passed? There was a show cause.
So cause was issued to me, my lord. I find
And what was the show cause?
so cause is that, my lord, I have
No. Read the last line of PEP, Annexus C. Last paragraph
Yes,
of
yes,
Annexus C.
page 15.
yes, my lord. Your reply, my lord, is therefore you are asked to so cause which disciplinary action should not be initiated. Yes, my lord. And I have filed a reply also to that.
No. So the show cause was prior
initiate.
to a disciplinary proceedings being initiated under Rule 9.
Yes.
So they were asking as to whether they should initiate a disciplinary proceedings or not. And there they found that yes, it is necessary, we are not satisfied, and as such, we are going ahead. So that will be decided under Rule 9. Where is the memorandum of charge being given to you? You know how a memorandum of this thing, it has to be done in terms of Rule 9 too. Then
In that case,
you get your opportunity, fight it out there.
Right.
We are not interfering with the order of stay transfer, but we are only, this court is only making it clear that this order of transfer shall not affect the directions given to that effect that they will initiate departmental proceeding.
But in fact, kindly come to para 7 of our petition.
Yes, what does it say?
Para,
Do you need anything more than that?
page 7, para
No,
7.
no, Mr. Nath,
They
do you need anything more than that?
They have already taken a decision not to pursue with the transfer. That is what I am indicating. Because the honorable court has already expressed the view that prima facie it is punitive. They are not pursuing it. Only the departmental proceeding they want to pursue.
So then what remains in the petition?
Nothing. Look, may I read para 7? The applicant respectfully.
The dispose of the petition then,
Yes, sir.
saying that they are not going to insist on the transfer order.
yes, my lord.
And however, liberty is given to initiate departmental proceeding if they so feel like
Yes.
in terms with Rule 9. Let them do it. You
Yes, my
fine.
lord. And I will be given opportunity. That will be there.
Obviously,
Yes.
Sir.
if it is not given, then you can
Yes.
very well knock the doors of this court.
Yes.
Okay, heard, Mr. Your name, you are the petitioner.
Yes, my lord. Yes, sir.
So and so the learned counsel appearing on behalf of the petitioner, Mr. D. Nath appears on behalf of all the
respondents.
on the learned senior government advocate appears on behalf of all the respondents. The instant petition was filed challenging the order dated 9/5/2023, whereby the petitioner herein was transferred from the post of the supervisor Korunabari ICDS project Lakhimpur to the post of the office to the office of the Majuli ICDS project, Majuli. It appears from the records that this court by an order dated 17/5/2023, taking into consideration that the perusal of the order dated the impugned order dated 9/5/2023 was punitive in nature, state the order operation of the transfer order dated 9/5/2023, and further observe that the petitioner shall be allowed to work as a supervisor at Corunabari ICDS project until further orders. The respondents in the writ petition has filed an application for vacating of vacation, modification, and or alteration of the order dated 17/5/2023, which have been registered and numbered as IAC number 1706/2023. The Learned Counsel, Senior Government Advocate, submits that the said application be treated as the affidavit of the respondent authorities. Attention of this court was drawn to the impugned order dated 9/5/2023, wherein not only there was a direction to transfer the petitioner from Corunabari ICDS project Lakhimpur to the office of the Majuli ICDS project, Majuli. But there was also a direction to the Joint Director, Women and Child Development and Branch Officer, Eastern Establishment Branch, to initiate disciplinary proceedings against the petitioner for violation of official discipline and decorum and insubordination to the higher authority as per the provisions of the Assam Service Discipline and Appeal Rules 1964. The Learned Counsel, Senior Government Advocate, the Learned Senior Government Advocate had submitted that in view of the order dated 9/5/2023 having been stayed by this court, the proposed disciplinary proceedings, which is required to be drawn up in terms with Rule 9 of the Assam Services Discipline and Appeal Rules 1964, could not be proceeded with. And it is under such circumstances the application has been filed for vacation, modification, or alteration of the order dated 17/5/2023. The Learned Senior Government Advocate further has drawn the attention of this court to paragraph number 7 of the said application and submitted that the respondent authorities are not going to pursue with the said transfer order dated 9/5/2023, as taking into account that this court in the order dated 17/5/2023 have already observed that the said order was punitive in nature. Upon hearing the learned counsels for the parties and taking into account that the cause of action for filing the instant writ petition was to challenge the order of transfer dated 9/5/2023, and the specific undertaking being given at paragraph number 7 of this application, to the effect that the respondent authorities are not going to pursue with the order dated 9/5/2023. This court is of the opinion that nothing survives in the instant writ petition. Full stop. The learned counsel for the writ petitioner, however, submitted that the petitioner apprehends that the respondent authorities shall not conduct the disciplinary proceedings in the manner envisaged under the provisions of the Assam Services Discipline and Appeal Rules 1964. The Learned Counsel Senior Government Advocate, however, submits that steps as regards the disciplinary proceedings shall be done in compliance with the rule 9 of the said rules. Taking into account the above, this court therefore closes the writ petition in view of the specific statement made at paragraph number 7 that the respondent authorities shall not pursue the transfer order dated 9/5/2023. This court further grants the liberty to the respondent authorities to pursue, to initiate disciplinary actions in terms with the provisions of the Assam Service Bench Discipline and Appeal Rules 1964. With the above, the petition stands disposed. The interlocutory applications that they give, disposed. Pending applications, if any, also stands disposed in view of the above order. I cannot that in view of the order passed in the writ petition, the I stands closed.
Not pursuing the first part, the second part of the 9.
I made it clear.
Not-
You said you had liberty to pursue
Not-
the disciplinary proceedings.
Okay.
8. Yes, Mr. Datta, this matter is not leaving this court. Huh? Under no circumstances I tried. Yes, Mr. Warbuze.
My lord, I am seeking accommodation of 4 weeks, my lord. I have communicated to the department. We are seeking some time, my lord, to furnish the instructions. Because that finance department message, my lord, on the basis of which that notification appearing at page 27.
Interpretation to the notification dated 9/7/2, which is based upon a message by the Finance Establishment Department. This court is the opinion that an affidavit from the Finance Department, Government would be necessary as regards the notification and as to whether any further notification has been issued by the in that regard. The learned Mr. R. Borpujari, the learned counsel appearing on behalf of the Finance Department, submits that in terms with the order dated 2/6/2023 passed by this court, the affidavit has not yet been filed and seeks for an accommodation. List the matter again on 26th of July 2023.
My lord, can it be in the first week of August with all respect, my lord? First week
Okay.
of August, any date, my lord.
On 2nd of August
My lord.
2023, on which date the Finance Department shall file the affidavit without fail.
And so, my lord.
9.
Yes.
As per Lordship's direction, we have filed affidavit, Lordship.
Oh, Mr. Gogoi, that matter, he was there, Mr. Samu was there. That UCC matter, you appeared, remember?
Lordship.
Where
said this
there
was
were 2 repetitions
Lordship has
taken up
disposed of.
together.
Anju Sharma, Lordship has disposed of.
Two
Regarding conditional appointment, next late, Lordship.
not here. That matter, remember the UCC MPhil, he was not, he
Lordship,
didn't have it. And there was a direction by which the Director of Higher Education had directed.
Lordship.
And this court held it,
Lordship.
that was required.
Lordship. Anju
Huh?
Sharma's case, Lordship has delivered the judgment.
Ah.
Lordship. I have that.
He was there, na?
Lordship.
Ah.
Today, one matter is came similar line matter.
That is what I was looking for you.
Lordship, I will place the judgment next day,
Yes,
Lordship.
Yes,
This
Mr.
file I'll seek accommodation for today, my lord. Mr. Senior Counsel, Mr. Aichur is appearing on
For what matter?
this matter, my lord, item 9.
You have paid the court fee?
Yes, my lord, it has been paid.
You have filed the affidavit?
We have filed, as per Lordship's direction, we have filed, Lordship,
Ah.
by annexing the undertakings as well as the decision of the MSA, Lordship.
Oh. You have filed your reply?
No, I will file them.
Why?
In the course of instructions, my lord.
These are all matters.
Lordship.
How can I grant an adjournment?
Just for this today, my lord.
Why?
I am not very well thorough, my lord, because I tried to argue, but the ex was about to fall on me.
Huh?
So, my lord, the gavel was going against me, my lord. So I informed the petitioners that I am not able to communicate your grievances properly. So my lord, they went to Mr. Chaudhary, my lord, so.
Understood, but Mr. Chaudhary is the senior counsel, isn't he?
Yes, my lord.
And you know the senior counsels are daily wages? Yes.
That is up to them, my lord.
Yes.
Just for today, my lord.
Then how can I accommodate on the basis of a senior counsel?
Just for today. I pray on his
You
behalf.
tell me some other good reasons, I'll accept it, not
That
on the
is there,
ground
my
of a
lord.
senior counsel.
Apart from that, my lord, I was in Kohima. I reached at 4 in the morning.
That becomes a much
That
better.
was, I just came for.
You
this
didn't
matter.
have a proper sleep out there for that, you can very well say, but not on the ground of a senior counsel.
So that might not be. Okay, my lord.
Yeah, that is a better ground. Heard Mr. D. Gogoi, the learned counsel, appearing on behalf of the petitioner, who submits that he reached Guwahati in the early hours of today, and as such have not prepared the matter for which, and seeks for an accommodation, list the matter after vacation.
Record our presence.
Yeah, Mr. K. Gogoi appears on behalf of the Higher Education Department and Mr. A. Samoa, and Mr. A. Samoa appears for the UGC.
Returnable that I will place that judgment loss in earlier.
Oh,
matters.
that matter, no?
Yes,
Ah.
Lordship.
But that is otherwise covered. That is,
Lordship judgment is covered, Lordship.
And number 10 to 22.
Yes, what is the matter about?
Lord, the matter about, my matter, my lord, is we are claiming regularization as downward, my lord. My lord,
Why we are having the chief minister's vigilance cell and all these things?
Lord, what has happened, my lord, later on when there some appointment has been made,
Hmm.
my lord, an FIR had been lodged
Hmm.
against the, my lord, selection process, my lord. And subsequently, the chief minister's vigilance cell has, my lord, inquired into, and a charge sheet has also been filed. My lord, I have.
No, but tell me,
My-
with the, now you are having the rules now amended something.
Yes.
And by which these
You were-
appointments have to be by way of advertisement.
Yes.
What remains in this petition?
That's.
No, my lord, it is
Nothing.
the prior of the advertisement, my lord.
Huh?
This, my lord, petition was filed prior to the.
So what?
advertisement.
As of now, we are to follow the law which is at present.
My lord,
Huh?
my lord, that's why, my lord, I prayed for an adjournment, my lord,
For what?
for immediately after the vacation, my lord.
For what?
Yes, my lord, I am.
You are going to change the law.
No,
Then,
that is not the issue, my lord. I am praying that.
बाकी की तो case क्यों हो? Huh? What are the other matters?
Same.
They were asking for,
Regularization.
what is this regularization when you have the rules? You challenge the rules. You dismiss all these repetitions, unnecessary repetitions shouldn't be there.
Immediately after the.
No.
My lord, maybe, my lord, I am not well today, my lord.
You are not well, no problem. What about the others? Where's the others? You take your part. Yes, Mr. Counsel, you are there in some matter.
Kindly take up item number 19 and 21.
He did you.
I can.
You can go. I dismiss the other petition. Then Mr. S.S. Roy will very well say tomorrow that matter is covered by the division single bench judge. Yes,
Item number.
Lordship may kindly take up item number 19.
9.
No. Oh. 19.
Yes,
Lordship, in this case, Lordship, I have challenged the selection of expert number 7, Azimuddin.
Hmm.
On the ground that he does not belong to the jurisdictional area under lot number 14.
Hmm.
And he has applied only for the lot number 13. But he has been in the select list, he has been shown to have been
so this matter is different.
different.
So
Now-
it can't be a matter pertaining because this is as per the rules.
Now subsequently, Lordship, I have filed a rejoinder affidavit, wherein Lordship, I have got the Lordship search sheet file in the vigilance case, Lordship. May kindly
There is
take
a
my-
appeal provision.
take my rejoinder.
In that case, Lordship, there is a appeal provision. They have challenged the selection of that.
No.
Appeal is
Appeal is
okay, that's another aspect of the matter, but that cannot be the same matter with that matter. That matter has
It
to go.
is different. Lordship, may kindly take my rejoinder affidavit, it is there, Lordship. Now, whatever I have made my contention in the writ petition, that has been proved in the CM vigilance report charge sheet, Lordship.
Hmm.
Lordship will find that, charge sheet, I have not,
Affidavit in reply.
yes, no, Lordship, I have filed a rejoinder affidavit
Ah.
on 18/1/2023.
18-1.
2023.
Okay. What have you enclosed?
I have enclosed the Lordship charge sheet, filing the special judge, the final form report. I have only submitted the extract one, Lordship.
Where? You're relying on which one?
Annexure 1, page 80, the relevant portion. The relevant portion, Lordship, will come,
First of all, you should have the running pages. Nowadays, we don't have that page number any further. Yes, tell me.
page 91, Lordship.
Page 91, where do I get the 91 business now? Yes, 93, 91.
91. Lordship. Page 91.
Yes.
91, your Lordship will find at 1714.
During
During
the
investigation, it is found that one selected candidate, namely Azimuddin, son of Nizam Lakar of Kharawanda, applied for lot number 13, but was selected against lot number 14. In the interview, said Cyber Rahman, deed and ADC, member of the selection board, had shown his name against lot number 14 by overrating lot number 13 without making any initial. This is the finding in the third state lot. And all the 4 persons, selected persons, they were arrested also, including the deputy commissioners. He was drilled. Cyber Rahman, he was in judicial custody, and 2 more.
and what about Azimuddin?
Azimuddin, Lordship, he has subsequently, he has been appointed. Lordship. He has been appointed. Because there was no any interim stay order in this. Lordship.
Yes, what do you say on this?
Lordship. There was a corrigendum, Lordship, on lot number 14, Lordship, that.
Or you don't accept the police investigation?
No, Lordship.
Then it's a different thing if you may not accept police investigation.
And Lordship, there is one more note at page 86. Lordship.
Hmm?
There is one more note, the brief background of the case at page 86 by the intercept sheet itself. Brief of the case,
Page 86.
page 86.
Again, Mr. Counsel, wait, very difficult. Yes, brief background. Yes.
Brief of the case is that complainant Rahul Amin and 20 others submitted a complaint petition.
Who is Rahul Amin?
That
That was
item number
Item
number 1.
10.
10.
Okay.
Alleging that Mrs. Atika Sultana, ACS, did and Deputy Commissioner, South Salmara Mankasar District, and Mr. Cyber Rahman, ACS, did an additional Deputy Commissioner, South Salmara Mankasar District, illegally appointed 70 number of Gaonpura village headmen, violating the government rules and procedures in 2018 by taking bribes at the rate of ₹5 to 12 lakhs from each of the candidates.
Hmm.
Then facts disclosed during the investigation, I have always found the relevant person in respect of the selection of respondent number 7.
It was corrigendum. 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 Huh? Itu ultimately corrigendum model. We are based on the code we have there.
Who were there in the selection board?
Atika Sultana, he was the at the point of that they were working as a deputy commissioner of South Salmara Mankasar. Then one selection member was Cyber Rahman, he was working as ADC, who was also the member secretary, and 2 other members were Bikram Aditya Bora, who was serving as the circle officer of Mankasar, and AK Ilyas and Ahmed. He was the circle officer of South Salmara. And Lordship, I have also brought on record, Lordship, the one bail, anticipatory bail order, which was rejected, filed by the Atkas, the particular deputy commissioner, which was rejected. Your Lordship will find at page 95. And there are some remarks. Lordship.
And what does the government say in their affidavit about this thing?
Nothing, Lord.
That they were not taken into confidence. No, they may say. Nowadays, government says, nah, you pass an order against one department, the other department says that they were not taken into confidence.
And in the bail order also, Lordship will find.
Now, how do they support this? What do you say? Well, Mr. Roy, what do you say on this? That the entire selection was taken on the basis of taking illegal gratification? How do you take care of that?
Under lordship, then under trial lordship, this is under investigation, they have found lordship, but thereafter lordship, I have no instruction what
Are you saying that the investigation was not properly done?
that lordship. Now lordship, that I cannot,
No, but that is the investigation.
it was the investigation, but lordship, we have filed our affidavit in terms of the corrigendum, whatever the instruction we have received from the officers, lordship.
So,
The lordship. To that effect, lordship, this investigation, lordship,
yes, you are the main sole person, na? The revenue. Yes, tell me. It is all at your behest, everybody has done.
Lordship, my lord, that selection process, everything is done by the deputy commissioner, my lord. We are, my lord, not over, my lord, that involved in the, my lord, that selection process.
So you want to disown.
No, my lord, that is not.
Huh?
Even then, lordship.
Yes, Mr. Islam. You are 11,
Yes. Child for the private.
7.
7.
You were in lot number 14.
14.
You filed your application for lot number which one?
14.
Then how were you appointed in 13?
We applied at 13 years.
Huh?
13. At that time, your lordship, at the time of election, this is a newly selection, your lordship. Your lordship. At
What
that
is the
time,
basis of this lot number business?
Lot number business, your lordship. There is a lot here. There is a lot here, but it's a newly created lot here. But at that time, they have filed application of the standard form, and there is no provision for lot here. Only they have filed their document that submit their
So you did not submit your lot.
lot, because it's the standard form, they have submitted the form.
So there was no option for lot.
Officially, they have been prepared. After that, they called for the lot, again, under which fall in under this lot, your lordship.
So was the advertisement? Where is it?
Yes, Lord. Lordship, before that, Lordship, advertisement, Lordship. Page 23.
Yeah. You all should be a citizen of India. Given to the family members. And to the document with the
Until 20.
appointment of Gamburas in the number of Gambura lots, 70 numbers in Mankasa Revenue Circle and 24 in South Salmara Revenue Circle in the district. In pursuance to the government notification dated. Then you don't have to say about the lot.
And Annexer 10, Lordship, page 60, horizontal, your Lordship will find that
Page
Annexer 10, page 60. Page 60.
60.
Okay.
And 9. Oh, yes, 10. Yes, tell me.
The Downward lot has been shown, and against that Lordship, the part which are the jurisdictional area that has been shown against.
In supersession of the earlier period, so and so, due to some clerical correction against lot numbers have been made. In respect of the name of selected and their father's name, and as the case may be for the post of Gamburas against various Gamburas. Azimuddin, lot number 14.
14.
We are concerned with 13 or 14.
13, 14. 14 lot.
We are concerned with 14.
14.
Earlier it was put at 13.
Lot.
He put it as 13.
He applied for lot number 13.
How do you say so?
Lordship,
Except that
investigation.
investigation, how do you say so? Because the advertisement does not say where you have to apply for lot. Does it say so?
No.
yes, Lord, it is there, Lordship.
Where?
Because Lordship,
Chalo, we'll hear it again at 2.
My matter may be segregated. Taken up.
Don't worry. Your petition will be there. Don't worry. I won't dismiss it today. I won't dismiss it. But just thinking about allowing his petition. Provided he shows that.
Affidavit
In your,
reply Lordship, filed on 11/12/2020. Lordship, I am sorry, Lordship, running page not done by me. Internal page. Affidavit in opposition, affidavit in reply,
page,
page 9, Lordship. Lordship will find it third, Lordship, page 9.
affidavit in reply.
Affidavit in opposition.
Huh?
Yes, affidavit in reply, yes. Affidavit in reply, filed on 11/12/2020.
11/12.
11/12/2020.
There's a running page now. Why don't you get these things corrected in your thing? Because very difficult. Nowadays we don't have page, no? Yes. Page,
Page 9. Lordship will find it serial number 106.
wait,
Yes.
yes.
Lordship will find application serial number 106. Application serial number 298. Azimuddin is the response number 7.
At 13.
Yes, he has applied for lot number 13. And Lordship, you will find at serial number 110. Application serial number 13. Mokibur Hussain is the petitioner. He has applied for lot number 14. And Lordship, I will also like to draw your Lordship attention to page running page number, Lordship, page 95. Lordship.
Yes.
Lordship, this is an anticipatory bail application filed by the Deputy Commissioner, Lordship, Atika Sultana. And Lordship, this honorable court has gone for a case direct. Next page, page 96.
No, you're referring where?
Page
Page 95
Oh,
of the
Running
rejoinder
page.
affidavit.
page 95 is it's Office of the Assistant Settlement Officer. Of which document?
My rejoinder affidavit.
Now rejoinder
Page
again
81,
comes on a
2020.
different one. I have not copied it. Yes. Very difficult again.
Lordship, sorry, Lord.
No, you see, why I'm saying is, see, kindly have a look at the file. It becomes so difficult. See this, you don't have that page number any further. Page 95,
Annex
if you see the scratch portion, it is 149. Then tell me.
Lordship, this is an anticipatory bail application
Hmm.
filed by the Deputy Commissioner, Lordship.
Hmm.
In this case, Lordship, the honorable court has perused the case that page 96. Lordship, may kindly see, Lordship, during investigation from the second, third paragraph, it was found that Saibur Rahman, ADC, along with the present petitioner, the DC, and the other officials, including circle officer, has indulged in unfair means in the process of selection by way of illegal gratification.
No, this is what has been mentioned in the charge sheet also.
Yes. And
Then,
it's been found in the this all
no, what is the basis in the advertisement, how this lot number is to be mentioned?
Lordship, in our affidavit, page number, running page 89.
Running page.
89. We have mentioned that 13 and 14, these two villages come under lot number 13 and 14. Respondent number 7 and page number 89.
Yes.
That Lordship serial number 13, Mankachar, and serial number 14. Both this lot number 13 and 14. This petitioner's village and respondent number 7 village come under lot number 13 and 14. And now my friend says, Lordship, he has applied for lot number 13 and 14, both lot. He have just
Report may be called for your.
he has applied for 13 and 14.
Petition, respondent number 7, please fall under 13 and 14. Where was the part? 13 and 14, it is mentioned, and he applied in the standard form, they have written it
Okay,
13,
okay.
14.
So you mean to say you belong to
Kariwanda.
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 Bonda?
My
Yes.
village is Kariwanda.
He belongs to Kharawanda Part 2, Lordship. That is, Lordship, lot number 14 consists of Kharawanda Part 1 and Pulesar Part 1.
Not part 1, part.
And Lordship, lot number 13 consists of Kharawanda Part 2 and Hatchingimari.
Where is that part 2 mentioned?
Not mentioned.
Not
part,
mentioned.
Not mentioned.
Part,
This is a part.
part, no.
Part, Lord.
Then,
Kharawanda
two.
Part 1 and Pulesar Part 1 is the.
where are you? Because if you see, if this court has to hold it, then you see Pulesar is part 1.
Yes.
Whereas lot number 15, Pulesar is again part 1.
Right.
Tekamari part 2.
Part two.
So is this lot on the basis of residence?
Resident. Resident and land.
Land.
Also.
So you applied for what?
13 and 14.
13 and 14 because my residence is 13 and 14. Part. In fact, it is a newly created lot. At the time of application, lot was not clearly demarcated here. 2015, it's a newly created lot. That is not properly demarcated. Those land is there, it belongs to that village. It also belongs to that village, Kariwanda, that they applied in the standard form. They had written in the top of the list 13, 14 at the time of submitting our form.
Okay, now tell me, lot is okay, but what else? What is the basis on which the person is considered? Can a person apply for both lots?
Lordship. As per this lordship, this advertisement, it can appear in both the
No,
lots.
no. Can a person apply for both lots?
If the villages are there, lordship.
No. You tell me if it is apply for both lots, it is okay. But is it mentioned that can you apply for both lots?
No, lordship. As per advertisement, it says kindly comes.
There the concern. Then how did he apply for 2?
He must be part of.
No, whatever may be, can he apply for 2? If he can't apply for 2, then how did you accept his application at all? Show me. Advertisement, where does it say?
As per my instruction, your lordship, they
Has to
apply-
fulfill the following minimum qualifications in clause so and so. To be physically fit, it should have a declared so and
Must
so.
have land.
Documents certificate, certified copy, latest so and so. Then, this advertisement does not say anything.
He should be citizen, permanent resident of the area in respect of which he seeks appointments.
Where?
At page 23, lordship. 1. She should be citizen of India and permanent resident of the area in respect of which he or she seeks appointment.
So, your things are not clear on this aspect.
Lordship.
And taking advantage of that, you have given it to them.
Lordship.
Now, isn't it clear from that?
Lordship. Lordship, then record may be called for where he applied.
You know the records are with the
No.
See-
TM Vigilance cell.
Huh? The applied, the selection, applied forms are, I have to take instruction whether this was there or not, whether they have seized it or not. TM.
There is obviously seized when the, on what basis would the charge sheet will be given, saying that there was an overwriting.
If lordship orders, then we can produce lordship. That huh? Photocopy can be produced if lordship orders.
Lordship, in the list of accepted candidates, there is
But this was not signed by anybody,
in
lordship.
the
That
list of
doc-
accepted
that
candidates, Lordship,
document
in
which
lot
is
number
relying not
13,
signed by anybody, lordship.
lot
This is
number,
just a document accepted list.
Which document?
he has not
To
applied
which
for lot
he is
number 14.
relying.
He has
lordship.
not applied for lot number 14. It has been reflected from the list of accepted candidates. I have just now confirmed.
That too you have not.
Lordship.
If he has not applied, We have to see the application
Lordship, yes.
because there was an overwriting. That is what has been alleged in the charge sheet.
Lordship, that can.
Because the charge sheet categorically says, kindly come to this
Seven-
one, yes,
91.
1714.
Lordship, same.
During investigation, it is found that one selected candidate applied for lot number 13,
13.
but was selected against lot number 14. In the interview sheet, so and so the then ADC has shown his name as lot number 14 by overwriting lot number 13 without making any initial. So there is an overwritten with that.
In the selection list.
Is it your case that you applied for both lots?
As per my instruction, your lordship, they.
No,
applied-
have you filed affidavit?
No, your lordship. I have not filed yet.
Oh.
Filed
Doc-
after package, filed yet.
The doctrine of non-traverse, what he has accepted, we have to accept.
No, it.
Have you stated out here as to where he has applied?
That,
Why haven't you filed affidavit? You're not concerned. When was the petition filed? 2019. Then
Right, the independent and I have subsequently appeared and in the another petition was filed by the respondent.
no, we are concerned with this petition. Would the order passed by this court strike out your your appointment as Gambura? Can it be dislodged by an order by passed in petition? Then you have nothing to say. Why haven't you filed your reply?
After vacation, right. Immediately after vacation, but the series come some other cases also there.
Huh?
Some other the series cases are there. In connection with this, I have not filed yet.
Who is appearing for the other petitioners in this petition, in this batch? You are appearing for how many matters?
5 minutes.
Huh?
5
All are similar.
No, 21 is similar. 21 is similar, but the private respondent has not been appointed, and then there is a stay order.
Okay.
No one has been appointed. And in that case also,
Then who is running it?
no one was. Actually, out of 70 selected candidates, in 2 cases they are interim order, including this lot. In this case, there was no interim order. 67 appointments were made. And in this case also no appointment was made. Subsequently, he filed an interlocutory application since there is no any restraining order. Initially, no appointment was made against charge number 13. Then he filed the interlocutory application saying that since there is no restraining order, I should be appointed. Initially, there was a blanket stay order passed by this honorable court by Justice Montiam. And thereafter, the selected candidates come up with an interlocutory application for modification of the state order. In 2021 only, 70 out of 70, 67 were appointed.
And when was the charge sheet given?
Charge sheet was given
There will be a date of the charge sheet.
Lordship.
30/11/2021.
Okay. And was the interim order vacated prior to that?
Prior to that.
No, in this case, there was no interim order, but
Did he file an IA?
he filed an IA.
Was the order passed in the IA prior to the charge sheet? When was the order passed in the IA? Yes, when did you file the IA?
In this case, I have not. In this case, I have not filed.
There's no IA file here.
Or nine. I have filed another writ petition, your lordship, 1013/2021. Because we are selected, but we are not appointed due to pendency of this court. After that, the respondents they have appointed me. Responded. Therefore, they are.
What happened to that matter?
That petition is withdrawn subsequently.
In this case, I'm wrong.
11/26.
Now, in view of this, we You have not filed your reply, we stay your appointment. We'll see later. Heard, mister, and you get all of your. Heard, mister, your name?
SK.
SK Das, the learned counsel appearing on behalf of, appears on behalf of the petitioner. Mr. SS Roy appears on behalf of
Respondent number, Lordship.
the respondent numbers
And for one. 2, 3, 4, 5, and 6.
2, 3, 4, 5, and 6. Mr. J. Hendrik appears on behalf of the respondent number 1. Mr. S. Islam appears on behalf of the respondent number 7. The instant writ petition was filed challenging the appointment challenging the selection of the respondent number 7 as regular Gaumbura in lot number 14. Challenging the selection of the respondent number 7 as regular Gaumbura in lot number 14. Of 14 under Mankasar Revenue Circle in the district of South Salmara and Mankasar. The record reveals that various pleadings have been filed by the respondent authorities. And the petitioner had also filed affidavit in reply. The respondent number 7, however, in spite of putting in appearance, when did it appear? Mr. Islam,
21.
in spite of putting in appearance, what is the name of the respondent?
Azimuddin.
Azizul Islam.
Azimuddin.
In spite being a caveator, you are a caveator. Azizul Islam, na?
Azimuddin.
This is Azizul. No? Caveat ko na. Caveat ko. Ano na yung parat naman?
90. Give it. 90.
Caveat. Caveat. Untuk petitioner. Respondent online. Huh? Caveat na. In spite of entering appearance on behalf of the respondent number 7, there has been no pleadings filed. Be that as it may, it appears from the charge sheet submitted by the Chief Minister's Vigilance, PS. In Vigilance PS case number 5/2021 on 29/11/2021. That there has been certain manipulation in the interview sheet by one Saibar Rahman, the then ADC, whereby the respondent number 7, having applied in lot number 13, was selected against lot number 14 by overwriting in lot number 13. Overwriting lot number 13 without any initial. It further transpires from the said allegations made in the charge sheet against the then officials that they have taken huge amounts of gratifications while carrying out selection of Gambura. And accordingly, the charge sheet was filed under section 120B/420/468/471 of the Indian Penal Code, read with section 7A, B, C, /13(1), A, /13(2) of the Prevention of Corruption Act 2000, Amendment Act 2018. The learned counsel appearing on behalf of the respondent number 2 to 6 submits this court put a specific query upon the learned counsel appearing on behalf of the respondent number 2 to 6, upon the learned counsel for the respondent number 2 to 6, as to whether the said respondents agree to the view as stated in, agree to the opinion as stated in the charge sheet. The learned counsel, with all fairness, submits that the official respondents do not differ with the opinion as stated in the said charge sheet. Taking into account the above, and more particularly as the respondent number 7 has not filed any affidavit in spite of the fact that the petition was filed in the year 2019. This court is of the opinion that it will be in the interest of justice that the selection and appointment of the respondent number 7 as the Gamura of lot number 14 under
Under Mankasa Revenue Service,
Revenue Circle
Mankasa Revenue Service.
be state pending disposal of the instant petition.
Already appointed, Lord. Already appointed.
That is why I say selection and appointment of respondent number AI is state. The the respondent number 2 to 6 is further directed to produce the selection details in respect to the present lot, in respect to lot number 13 and 14 before this court on the next date. List the matter again on 8th of August for further consideration.
From the office of the CM Vigilance Club.
I'm not saying you get it from wherever you
The order, copy of the order.
take out the printout. What about the other matters?
Item number 21 is also same.
Who is appearing for 21? Respondent?
Only the respondent number 1 has filed an affidavit. None has appeared. And in
One
this
is
case, in this case,
revenue. And there also the same problem.
same problem. In this
There
case,
is no stay.
there is a stay.
Oh, then no problem. We can take it. Then anything else? Your matter? Ten and 20 both are same. Both are same. Those petitions are liable to be dismissed. And what about the others? Others are, let me put it at non-appearance, dismiss for default, get some disposal out there, none has appeared. Yes. Take it up, I get it, distegate it and dismiss for default.
In item number 11, there is a stay.
Now, other matters where none is appearing, dismiss for default.
In item number 11, item number
10 to okay.
there is no affidavit filed by the government. Item number 11 and 18, no affidavit has been filed by the government.
You are appearing in 11?
11, yes.
12, H.I. Chaudhary. Not appearing. What is that case about? 2018 matter?
That lordship is regularized. This is all our regularization. Regularization, similar to item number 10.
It is similar to item number 10. Let me dismiss this one. Then others will follow. This is all 18 matters must be same.
Lordship.
All are same.
All 18 matters must be prior to that, no?
Lordship.
Prior to that notification. Now these 19 matters must be different.
19 matter, those two are some of the advertisers met. Only one of the South Salmara Mankasa advertisers met and against that advertisement discussed. Election was
That was the illegality.
Lordship that.
All other matters pertain to South Salma Mankasa.
Different.
Some are Dhubri district, some are.
But there is no charge sheet in respect to those.
No. Dhubri district, my lord, I think so, my lord, that some process has been initiated by the government, my lord, that to going to my lord, that appoint a selector for advertising.
No, in other matters, do we record require the records?
Not.
And in item number 22, you are there? Have you paid the court fee?
No.
Huh? 64 petitioners paid the court fee?
No.
Item number 10, court fee. 87 petitioners, court fee.
No. Not paid.
I apologize, Lordship, which he may not be adequate,
Huh?
may not be adequate. Lordship.
Then
We'll do the needful. Lordship.
what about item number 11, Mr. Das?
One paid, not paid.
Court fee? 11 lose name, yeah. This order I had passed in 11.
No,
19.
Lordship,
19.
19.
What about 11? Have you paid the court fee?
Lordship will pay, Lordship. In this case also, Lordship, we have challenged the notification dated 10/4/2018.
Why have you challenged that? Same.
10 for one lot.
Lordship, that in that case, we have
For regularization.
to allow them to participate in the selection process without insisting upon clause 7. Clause 7, Lordship, pertains to upper.
But now that
Now-
age has been done.
35.
So these amendments have happened. So what remains now? Withdraw. Instead of paying court fee of 120.
Regulation part is also clear.
Huh?
Regulation part is also clear, Lordship.
Regularization.
So, 10
How
and
can
11.
we regularize when they have a, you have to challenge the scheme.
Also, item number 10 and 11 may be taken up with the since item number 10 has been. Item number 10 and
No, no.
11 is same.
Then Mr. Bhuya is there. And dismiss this 11 now. Once I dismiss this 11, then this will follow the suit and Mr. Roy will on the next day say, oh, this will allow. Huh? What do you say?
Lot.
Or pay court fee? 120 into 60, 7,200. What do you say?
Possibly kindly, not only kindly come after today.
Court fee?
I'll option it whether to withdraw or to option to pay.
Court
this
fee,
court.
court fee, court.
Either we'll pay court
No,
fee
you
or.
can't pass beyond that. Court fee.
Yes.
You pay your deficit court fee. তাৰপিছত এটা বেলেগকে এটা সেইটো দিলে ন সেই আইটেমটো বেলেগ কৰি দিব সেইটোতো এজনে মানুহ that was only one person na that matter
Lot.
where is that matter yes
19.
there is only one person so not necessary but in বাকি matters কিনে এইকেইটা দিব হা এই item number 22 you give it in item number 10 put it as separate order item number 10 item number 11 item number 12 item number 13 item number 16 13 14 16
17 also.
এই গোটেইকেইটা যোনকেইটা এই তাতকে বেছি petition আছে না heard the learned counsels for the party it appears in the instant petition in the instant petition that there are more than one writ petitioner. However, espousing separate and distinct cause of action. Under such circumstances, however, it is seen from the records that the court fee of only one writ petitioner have been paid. The learned counsel appearing on behalf of the petitioner submits that he shall pay the deficit court fee on or before the next date. No, before the next date. List the matter, he matter to the logot logat.
Obliged.
Lordship, in item number 21, there is an interim order that I consider. There is an individual matter, Lordship, just
21 to K. 21 is
21 is similar to item number 19, Lordship. In that case also, we have brought on
item number
record.
21. Itu kurusya. Heard Mr. S.K. Das, the learned counsel for the petitioner. 21. Let the matter be again listed along with the. তার এইটুতে লিখিব হা এইটু let the matter again be listed on next duty. The interim order passed earlier shall continue till.
Obliged.
কম এটা থাকিলে নালাগে প্ৰায় কি
At number 51.
So he wants an upgrading and he is not here. Yes, any instructions?
Yes,
What is it?
Proposal for revision of the pension, Lordship. It was returned back to the department due to some lack of sufficient documents like service book, Lordship.
Related to payment to payment. Yes, in the government. Mr. Talukdar. Yes, why you are not submitting the papers properly?
Secondary matter, and they
Oh, non-appears for the secondary education.
He was here only, Lord.
Yes, madam. Here the director of pension says that the papers have been again had to be resubmitted. And a letter was issued, could not come to any solution and returned the proposal by the officer note dated so and so with a request to resubmit duplicate. When are you submitting? You have to submit it.
Notice some time may be given your lordship. Because the government has requested for some more time.
Heard Mr. and none appears on behalf of the petitioner on call. Oh, here the petitioner is never appearing. No, and again, none appears nearly. Mr. S.R. Borua, the learned counsel appearing on behalf of the director of pension, has drawn the attention to an instruction dated 6th of May 2023, whereby it was mentioned that the inspector of schools Amingaon, by the letter dated 1/6/2022, had submitted a proposal in respect to the petitioner for revision of family pension. But however, due to the lack of sufficient documents, the said proposal was returned by letter dated 22/3/2023 and with a request to resubmit the duplicate of the reconstructed service book in respect of the husband of the petitioner. The said document is kept on record and marked with the letter X. Ms. D. Musairi, the learned counsel appearing on behalf of the respondent on behalf of the Secondary Education Department, submits for an accommodation so that the appropriate instruction can be taken in that regard. First, you want that restructured duplicate copy, no?
Lordship.
Taking into account the communication dated 6/5/2023, this court therefore directs the inspector of schools, Amingaon, to take appropriate steps within 15 days from today for sending the duplicate oblique reconstructed service book of the husband of the petitioner to the director of pension. Full stop. Ms. D. Musari, the learned counsel, appearing on behalf of the respondent, Secondary Education Department, shall duly intimate the inspector of schools of the order passed hearing. The communication legislation is kept on record and marked with the letter. List the matter again on, well, 15 days here and another 15 days there. We'll have it today is 26, 27, 28. We'll have it on 7th of August.
Obliged.
Hello, 60.
Mayor, your lordship, can you, your lordship order, dated last order, 24/5, your lordship, 24/5. Para 4 and 5. Para 4.
Taking into account this,
Taking into account-
direct the secretary to government environment to pay the subsistence allowance for the period from so and so within a period.
Within a period of 3
from
weeks.
the date of submission. And the 4 weeks from the submission.
Well, this,
I have submitted your,
Departmental.
it is sanctioned.
let me finish.
And as regards also the DP, my lord.
So you are now paying?
No,
That part has to ascertain, my lord, because
no,
actual,
no, today I have obtained instruction, today itself,
Wait, wait.
no payment, your lordship. This is one,
This is on 13th of June.
this has been approved, my lord, this is an approval letter,
Find it out, we'll take it up after some time.
my lord.
Because this is on 13, we are 15 days thereafter. Till now, if it is not done, then something serious has to be done.
another extra also, your lordship, after passing of this order last on day, they have now appointed an inquiry officer after.
There was no bar to that, my
No,
lord.
no, there's.
Not fire,
No, that is not. bar.
You are
Well, there
getting
is-
we are concerned with the subsistence allowance.
yes,
We'll look into it.
and
You will take it up after some time.
Yes, I'm
Getting
taking
instruction.
there is also a
All this.
Supreme Court direction to
Item number 61.
conclude the departmental proceeding within 1 year. I have that judgment, your lordship.
Item number 61.
Premnath Bharti.
Yes.
My lord, in this case, I am for the respondent.
Hmm.
So I need 4 weeks time to file affidavit.
For what? The
Because
husband, you are the second wife?
I am the only wife.
And he?
She's, as per instructions, she is not the wife and she had collected the papers from where I have no idea. So all this has have to be inquired into and thereafter we shall file affidavit. The 4 weeks time may be granted.
My lord, this next of kin certificate
Hmm?
is 29,
Paid?
is 29, has to be challenged. Was issued after inquiry. And even in the land record, my lord, the petitioner has mutated.
Your name is what?
My lord, my name is
Anwara Khatun.
Anwar
Her name is Zubeda Khatun.
the second one. Even in the landed property, my lord, she has made some manipulation and after objection, that was.
What is this? Huh?
I have also annexed the birth certificate of my daughter, my lord, age 22. 3 daughter, I have 3 daughter, my lord,
Age?
age 21, annexure 2.
How many pages?
This is the death certificate, my lord, then annexure 3. page
Yes,
20.
who pays the pension? You.
You finalize the process.
How are you going to decide? Who is the pension? First and second wife?
I am getting the pension.
Well,
The
that
death
is
of-
go
Right now,
good.
I'm not
But
having
why
the
have you
instruction.
given it to her?
Right now, I am not having the instruction, Lordship, but I suppose perhaps in the nomination Her name was included.
No, can a nomination override the statutory rule?
That cannot.
Then-
But at that time, we cannot lordship determine lordship because we do whatever the documents submitted by the concerned department. Lordship.
So you are a better person to fact find that. Isn't you have the
That
resource?
has to be come from the department itself. Lord.
Who is the
Because
department?
We work on the proposal.
This
sent
is
by
the department. We are concerned with which department? Inspector of school.
Only page 34, that they have forwarded. The
Huh?
inspector of school has forwarded my application, page 34,
Page
34,
32.
34.
For inspector of school. And when was this forwarded?
Not on
When did the person die?
2020,
Your husband, when did he die?
it I don't,
Oh, your husband, you don't know?
my lord, he died on Annex 2, my lord, he died on
22,
3 to 2020.
23/3/2022.
Because my lord, respondent eight's names were written as the legal guardian of the minor, my lord. That is of the gratuity. Yeah, at page 19.
Yes, Mr. Khatania, do you see page 34?
Yes, ma'am.
This has been sent by the inspector of schools.
Claims to be the first type of enforcement. It has been communicated on 14/6/2022, madam.
Because after the death on 23/3.
Yes, madam.
Then also why the pension has been given? You are to write
No,
when the
this is
inspector of
sent-
schools
this
have
is
written.
sent without any finding. Anwara Khatun filed a petition that was forwarded without an opinion.
It's okay, but then also it was
And second
mentioned
thing,
out there that
Lordship,
why she was chosen in spite of this letter, because the death would have happened on 23/3. Yes, your name?
SK.
Heard Mr. S.K. Roy, the learned counsel appearing on behalf of the petitioner. Mr. N.J. Khatani appears on behalf of respondent numbers 1, 4, and 6. Mr. S.R. Bolwa appears for the respondent number 3 and 5. Mr. R. Babudari appears for respondent number 7. And you're there. Benzo appears for respondent number 2. And Mr. M.U. Mahmood appears for the respondent number 8.
Eight.
Mr. M.U. Mahmood, the learned counsel submits that the respondent number 8 would like to file an affidavit in opposition. As the said respondent denies that the petitioner is the first wife of late Abdus Sobur Kandakar. This court, by the order dated 24/5/2023, had directed the standing counsel for the director of pension to apprise this court as to why the petitioner has not been given the family pension. No instruction, however, has been received from the director of pension. During the course of hearing, the learned counsel for the petitioner draws the attention of this court to a communication dated 14/6/2022 issued by the Inspector of Schools BDC Bongaigaon, dated 14 enclosed as Annexure Roman 7 to the writ petition. It further transpires that late Abdul Sobur Kandakar expired on 23/3/2022. Under such circumstances, why the Director of Pension had paid the family pension to the respondent number 8 is required to be ascertained, for which the Director of Pension is directed to file an affidavit on or before the next date. List the matter again on 9th of August. The affidavit be filed by 7th of August.
Page 17, the PPO, which was issued in the year 2019. So at that time, the name of the family pensioner, we mentioned it. So this communication is up to 2022. So we have finalized it in the year 2019. So on the basis of that, this perhaps is getting the family pension order. On the basis of that, the finalization order, the PPO lordship, page 17 lordship. It was finalized on 30/10/2019. And lordship,
Whose name is there?
page 19 lordship. The Javeda Khatun, the second wife name is there.
Not I am second wife. I am only
sorry.
wife.
Oh, sorry.
We will look into it, whether you are the only wife or not. Why that was not taken into consideration?
Actually, my lord,
Because the family pension will be there, but then also when that document is there, what have you done on this? Because that document is a document written by them. What have you taken into account with that application? You must have, it is for you to decide on that. Or you had to address it to these people and stop the pension for both of them.
64.
The affidavit be filed by 7th of August, huh? By both. Yes.
In this matter, lordship, I pray for some time to file an additional affidavit.
Okay.
For some relevant document.
Huh?
I have to file some relevant document.
Let it come after petition. In the meantime, as the proposal may be cleared and the amount will be released.
The learned counsel for the petitioner seeks for an accommodation. Why this man? 64. Learned counsel for the petitioner seeks for an accommodation for filing an additional affidavit. List the matter after 4 weeks.
65.
Oh, yes, did you find out?
Lordship, here, the petitioner serial number 28. Otherwise it belongs to. He belongs to OBB category. And petitioner at serial number 30, Pranabjyoti Sonowal. He has been appointed on 14/11/2017. And rest are lordship appointed.
Rest are stipendary. I put it by way of an affidavit.
Lordship.
Why you are asking for those OBB then?
OBB, my lord, as per our information, my lord, number.
As per?
Our information, my lord.
What is this information business?
Information-
You have you filed the petition on the basis of,
Yes, document.
you should have asked them why those people have come up like this.
28 and 30 mile.
Then?
Rest are stipended mile. Rest petitioner belongs to stipended.
But why have you included everybody everywhere? That is the problem you face. Court fee has been paid for application.
Yes, in the writ petition we have paid for everyone.
Hmm.
In the writ petition we have paid for everyone.
No, this court fee for people like you has to be increased. Not because of other things, because of this problem, this has happened. If always stipendiary, it was so properly, you should have given it. Why did you insert an OBB insert? So that once I pass that order, then everybody goes through. Why did you insert the OBB?
It was not,
It's a very serious thing.
it was not within our knowledge.
Whose knowledge?
It was not my information.
Lawyer's information or the petitioner's information? Why didn't you check the papers? You must be aware. How does a person is appointed in OBB and one is a stipendiary? It's a very serious thing. Hey, hello, black book. Put his name. Okay. Mr. P.N. Sharma submits that the petitioner at serial number 28 and 30 do not belong to the stipendiary appointment. Do not belong to the category of stipendiary teachers.
Belongs to OBB category.
And they belong to the OBB both, na?
No, Lordship, one is OBB category and the other one has been appointed on 14/11/2007. Seven.
This is for the first time.
Lordship.
Then why did you apply? Mr. Protester, very serious. Why did you apply for 2007?
My lord, actually what happened, my lord, at the time of filing of the cases, my lord, all the documents were not provided to me, my lord.
Then why did you file it?
Then, my lord, after.
No. Why did you
And-
file it? It's a
and
very
my-
serious thing.
And my lord, what happened, and after the judgment, my lord, when we have found that, my lord, all category was the judgment is given, my lord. Thereafter, we have examined everything, my lord. And after examination, we have found that these two persons are not entitled. Therefore, I have filed the case, my lord.
Now, where have you stated that they were not entitled to in your
Yes, yes,
application? Tell me.
Yes, in the hospital itself, my lord, we have mentioned, my lord.
Where?
An application for correction of the inadvertent error of common final judgment and order dated such and such passed in WPC number such and such, wherein the case number of WPC number such and such, the state of affairs has been placed under the heading teachers appointed under Operation Blackboard at page number 370 of the judgment, instead of placing the same under the heading stipendary teachers, page number such and such,
Okay.
and for placing the same.
Done.
Yes, sir.
Heard Mr. B. Purkasta, the learner. We dispose it of. Heard Mr. B. Purkasta, the learned counsel appearing on behalf of the petitioner. Mr. P.N. Sharma appears on behalf of the respondent number 1, 2, 3, 4. To stop. Mr. Arbor Pujari appears for respondent number 5 and Mr. S.R. Borua appears for respondent number 6. This is an application filed for correction of an inadvertent error in passing the judgment and order dated 31/3/2023 passed in WPC number 4353/2022 along with various other writ petitions. Full stop. It is relevant to take note of that the writ petition was filed initially by 33 petitioners, 34 writ petitioners, claiming the benefits under the old pension scheme in terms with the Assam Service Pension Rules 1969. However, this court disposed of various writ petitions by the common judgment and order dated 31/3/2023, wherein the instant writ petition, wherein WPC number 4353 of 2022 was also disposed of. While disposing of the said writ petition, this court inadvertently categorized the writ petitioners in WPC number 4353/2022 in the category of Operation Blackboard teachers. Isn't it?
Yes.
It is under such circumstances the instant application was filed. Inadvertently, this court, while disposing of the categorized the instant the petitioners in WPC number 4353 of 2022 in the category of Operation Blackboard teachers. It is under such circumstances the instant application has been filed for rectification of the mistake which had occurred in the judgment and order dated 31/3/2023. It appears from the instant application that the petitioners, that all the applicants, it appears from a perusal of the instant application that all the petitioners in WPC number 4353 of 2022, except the petitioner at serial number 28, except the petitioners at serial number 28 and 30, would come within the ambit of the stipendiary teachers. This court, by an order dated 22/5/2023, issued notice, thereby directing the Standing Council for the Elementary Education Department to verify as to whether the petitioners would come within the ambit of stipendiary teachers so dealt with in the judgment of this court in the case of Purnima Hore and another versus the state of Assam and others reported in 2022 SCC 23 SCC online GAU 1165. Mr. P.N. Sharma, the Learned Counsel, appearing on behalf of the Elementary Education Department, submitted on instructions issued by the Director of Elementary Education that all the petitioners in WPC number 4353/2022 would come within the ambit of stipendiary teachers except the petitioner at serial number 28 and 30. Under such circumstances, this court is therefore of the opinion that the petitioners in WPC number 4353/2022, except petitioner numbers 28 and 30, would be entitled to the benefit of the stipendiary benefit so granted by this court to the stipendiary teachers in the judgment and order dated Purnima Hore and other Purnima Hore Supra. The respondent authorities therefore are directed to pass appropriate directions, pass appropriate consequential directions, thereby granting the benefits as directed in the order dated in the judgment and order in the grant such the benefits to the petitioner, the pass such consequential directions, thereby granting the benefits to the petitioners, to the applicants as stated. Full stop. The instant order shall be a part of the order dated 31/3/2023 passed by this court. The instructions so placed on record is kept, that is so submitted during the course of hearing is kept on record and marked with the letter X.
I've taken instructions, my lord. This is under process because this requires a separate budget and FOC, my lord. This is under process.
What?
This is, my lord, since it was a period which he had undergone suspension, since it has been approved, it requires a separate budget which has been presented, my lord. And it requires FOC, my lord. It is under process.
When?
It's under process, my lord. That's all it
When?
is. My lord.
We'll take up after some time. When? We'll fix a date, else the person has to come.
Okay,
Get your instructions.
my lord.
Give a date. Ask your people to give a date.
Well.
I know 23.
Madam, my lord, this is regarding area salary, my lord. And as per last order, my lord, perhaps, my lord, the area salary has been released, my lord.
Oh,
I have lack of instruction, my lord.
where is
Kindly
which
adjourn-
department?
Kindly adjourn for.
Elementary?
Yes.
Any instructions on this? He says that the area salary has been released.
My lord, as per last order 29/3, my lord, it may be repeated.
Yes, my lord. He has received the, we have disbursed the amount, my lord.
And my lord, it may be impacted, my lord, close. my
Heard, Mr.
K. Uttin.
Hmm?
K. Uttin.
The learned counsel for the petitioner. Mr. N.J. Khatonia appears for the Elementary Education Department and Mr. R. Borpujari appears on behalf of the Finance Department.
Yes.
It has been submitted by Mr. N.J. Khatonia, the learned counsel appearing on behalf of the Elementary Education Department that pursuant to the order dated 29/3/2023 passed by this court, the area salary
Yes, my lord.
have already been released and disbursed to the petitioner. Area salary of rupees 1,66,421. Have already been disbursed to the petitioner. In that view of the matter, the instant writ petition stands closed.
Obliged, lordship.
Item 24.
May I plead your.
Hmm.
Lordship, matter relates to lordship non-payment of salary and lordship non-regularization of leave period. Lordship, kindly peruse the last order 19/5.
P. Chakra Bhattacharjee, the learned counsel, heard Ms. P. Bhattacharjee, learned counsel, appearing on behalf of the petitioner. Ms. D. Bhusari appears on behalf of the School Education Department. It has been brought to the notice of this court that on notice of this court on the basis of an instruction issued by the additional secretary to the Government of Assam Department of School Education, that there is a proposal for inclusion of the name of the petitioner in the order of amalgamation order of Bipin Bora High School and regularization of her services. Which is presently being examined by the Director of Secondary Education. And as such, some further time has been sought in that regard. How much?
1 month.
List the matter again on 9th of August 2023 to apprise this court as to the further steps taken pursuant to the order dated 19/5/2023. The instructions were submitted by the Learned Counsel for the Secondary Education Department is kept on record and marked with the letter X.
25.
Okay. Departmental affidavit has been filed today. We've got the copy in our bag. We'll respond to that.
You want to file affidavit?
Yes, Lordship reply.
Ms. G. Go ahead. Wow. The Learned Counsel appearing on behalf of the petitioner seeks an accommodation of 4 weeks for filing and reply. List the matter. Ms. P. MM Kotoke appear for
Animal husbandry.
animal. And you
For respondent.
or accountant general.
26 and 27.
Name may be reflected. Madam.
This is what I said.
Like,
Hmm.
My lord, kindly see the last order, my lord.
Oh. Affidavit is filed by the higher degree failing to do so. Be filed by the year on or before a month, failing to the put notice to exemplary cost. Yes, affidavit filed.
No, my lord.
How we impose cost?
My lord, I have received certain instruction, but those instruction is my lord, not specific to file an my lord, affidavit. So if I may pay for the time, my lord.
Okay, cost of 10,000.
My lord, I have placed the instruction, my lord. I placed the instruction, my lord, that is not specific to the
I'd
petition.
like
my
to
lord.
state that as per the submission of PhD, MPhil certificate by various colleges for various reasons, it is direct. After submission of concern, it is deemed that the incumbents have been accorded a degree on distance more than the concerned universities are outside the state. Committee has been constituted by the Government of Assam Higher Education Department for verification of the according to the I have awarded the PhD certificate to the concerned universities for what type of instruction is that?
That, my lord, that is not, this doesn't reveal the, my lord, the case of the petitioner, what is his case, my lord. That's why, my lord, if the matter may be fixed after vacation, my lord, I will bring certain specific.
You
instruction.
impose the cost on the director of higher 10,000. Heard Mr. K.U. Ahmed, the Learned Counsel appearing on behalf of the petitioner. Mr. Your name?
Yes, that's my lord.
As does the Learned Counsel appearing on behalf of the Higher Education Department. This court by an order dated 2/6/2023 had directed the Higher Education Department to file the affidavit on or before 23/6/2023. It was further made clear that failing to do so, this court had also put to this court had also put to notice the said department that in the circumstance the respondent authorities fail to file their affidavit, exemplary cost to be imposed if there is a delay in filing the affidavit. Taking into account that there is neither any instructions available nor today, Mr. Esdas, appearing on behalf of the Director of Education, Higher Education, have placed an instruction which is not only vague but does not make any reference to the issues involved in the instant proceedings. The affidavit has also not been filed. Under such circumstances, this court fixes the matter again on 26th of July 2023. This court imposes a cost of rupees 10,000 to be paid by the Director of Higher Education within 15 days from the date of the instant order. It is made clear that if no affidavit is filed by the next day, this court shall take up the matter for disposal on the basis of the materials available on report. Oh, there are two petitions. 10,000, 10,000.
No, only 10,000. Similar issues, madam.
Two? 10,000, 10,000.
One affidavit, madam. This instruction, madam.
20,000 then?
Our both the cases, madam.
Okay. The said amount of rupees 10,000 shall be deposited in the registry of this court, and the counsel for the petitioner shall be at liberty to file appropriate application for release of the state of
Obliged.
Item 30.
Yes, Mr. Khan.
Kindly peruse the last order. Lordship, here I have the instruction, Lordship.
Yes.
As per my instruction, on receipt of the approval from the government, Lordship, for condonation of that shortfall of qualifying service period, Lordship, the Director, White Communication dated 20th of June, directed the District Elementary Education Officer to take necessary action and forward the proposal to the concerned authority, Lordship. That instruction is there, although I have received through WhatsApp just now. I have forwarded the copy. Print out mail kuri dishna. Just now kuri. Oh.
Yes, Mr. Who appears for the Director of Pension?
On 20th. 20th of June this month.
Oh, 20th.
3030.
Yes. Now what has happened? What did you say? From your instruction?
My instruction is, Lordship, that shortfall of that shortfall period approval has been received from the government, and the Director of Elementary, Lordship, that instruction. That has already been referred.
Mr. Sharma, have you read the last order of this court? What did Mr. N.J. Khatonia say? Read the last order of this court. When?
Lordship.
When are you going to do it?
Lordship from the director, yeah, it has already been sent to the DO. Now DO.
We are not concerned with the DO. We are concerned with whether the director of pension has got it or not.
Lord.
Well,
Another, immediately after vacation, your lordship can fix the matter.
Or-
By then,
or update on whether the pension has been released.
whether the DO
Pension has been released.
has.
I'm
sent
not concerned with other things because this court had made a very categorical submission,
Lordship.
observation out there. The director, the government has already approved,
Lordship.
and the director of pension, director of elementary education was had requested the secretary to the government of Assam for all purpose of returning the original service book and all other pension papers of the petitioner for immediate compliance of the orders passed.
Lordship.
It has been further mentioned by Mr. N.J. Khatonia, the learned counsel appearing on behalf of the Elementary Education Department, that he has been verbally instructed to inform this court that the government of Assam Department had on 23/5/2023 had already returned the service book along with all pension related papers of the petitioner to the Director of Elementary Education Assam, and the director is accordingly taking appropriate steps.
Lordship.
And thereafter, why does the director thereafter take 1 month to do so? We impose a cost of
Lord-
10,000 upon the director of, earlier it was higher education, now to element
Lordship, here,
10,000.
here the letter, the reference letter of the government approval is dated 29/5/2023. That reference is there in the
Yes,
list of
no,
applications.
we have also recorded out here.
Lordship.
Then
And by communication dated 20th June, they have already.
because on the last occasion we have done it, then
Lord.
why it has not yet been sent? Why you are asking the DO to do it and all these things?
It will be routed through DO.
No, we are not concerned to all these things.
Lordship will fix the matter immediately after vacation, perhaps by then that will be.
We fixed it the matter on 30 for further apply. Is not 30.
30.
Has the AR received the director of pension?
Lord.
Yes.
Lord.
Send it by whatever means.
Lordship.
Is not and this is the second time the petitioner is before this court.
Lord.
Why should we not impose cost upon you? See how many strict orders being passed, then also nothing happens. With so much of orders of petition should be disposed of only.
Lord.
I would have understood Mr. Khan saying that, my lord, the petition has become infructuous. This should have been. Look here, nothing has been done.
Lordship.
Heard Mr. M. Khan, the learned counsel, appearing on behalf of the petitioner. Mr. P. N. Sharma appears on behalf of the
Elementary.
Elementary Education Department, and Mr. S.R. Borua appears for the Director of Pension. Mr. S.R. Borua, the learned counsel, has submitted that till now, no papers pertaining to pension had been received from the office of from the Elementary Education Department. Mr. P. N. Sharma, the learned counsel, submits that till date, that the Director of Elementary Education had, by the communication dated 26/2023, had directed the District Elementary Education Officer to take necessary steps for finalization of the pension in the light of the government's letter dated 29/5/2023. This court fixes the matter again on 30/6/2023, on which date Mr. P. N. Sharma shall apprise as to whether the papers pertaining to the pension of the petitioner have been received by the Director of Pension.
Lord.
Received.
Lord.
They not sent, received.
Lordship. Public.
31.
Copy of the instruction is kept on record and marked with the letter X. Yes, madam.
Lordship, the case of the petition is that Lordship has service rendered.
Oh, I pass a long order.
Lordship,
Yes, Mr. Devnath. Under return, learned counsel appearing on behalf of and more particularly respond number shall indicate by way of an affidavit as to why the petitioner's family has not been worked out till date in terms with the directions passed by this court in so and so. Yes, tell me.
Look, I have received instructions, but not specifically with this.
Huh?
I have received an instruction, my lord,
But
but not exactly.
then,
And I've spoken to them, my lord. I received this last night.
no, no. Again on 12/6, the matter came up.
I-
Then also, here also nothing. Which department is this?
PNRDO.
PNRD. We impose cost of 10,000 pay. Then we'll see. You obtain. You want some time now?
This
Okay.
Friday one,
What time?
day after tomorrow.
Heard Miss P. Bulwer, the learned counsel appearing on behalf of the Honorable P. Bulwer. P. Bulwer, the learned counsel appearing on behalf of the petitioner. And Mr. N.K. Devnath appears on behalf of the respondent number 1, 4, and 6. This court, by an order dated 16/12/2022, after a detailed order, directed the respondent authorities to apprise this court by way of an affidavit as to why the petitioner's family pension have not been worked out till date, and fix the matter again on 6/1/2023. 6 months have passed by. More than 6 months have passed by. Till date, there is no instructions. List the matter again on 36/2023. It is made clear that if no instructions, that no relevant instructions are placed before this court would be constrained to impose exemplary cost upon the
Respondent.
Commissioner and Secretary to the Department of PNRD. This is notice.
Lordship, the item actually upgraded to practice.
You instruction will update. Don't apply.
Sorry, Lordship. In item number 30, Lordship, your Lordship have fixed on 30th, Lordship. Tomorrow being a holiday, Lordship.
That is
So
why.
practically, physically, it's not be possible. Lordship, direct to submit the document to the pension department by one.
I have given many directions.
Lord.
We'll have it on 36. Just find out
Lord.
even after they don't listen to the court's order is okay. But why they don't listen to even to the director of elementary education officer? Find out.
I will find out, Lordship. Otherwise, practically, there is some.
Not
If-
possible. It is
It might
possible.
have already been sent also. Lordship, that we will find.
DEO's office is where?
This is district Karimganj. Now pension department, they have to furnish here, Lord. So it will be practically difficult now. So Lordship may take up the matter on immediately on opening of the.
No. We'll have it on 36, whether it has been done or not. Or we impose some cost so that with that cost you can from that particular director of elementary education, with that cost you can send a Jarikarok and send the papers by flight.
Item 32
They have flight no, from Silchar to Guwahati. Yes, this side.
Yes, but
Yes.
like
Mr.
here,
Khatonia, all problem arose because of you in that case.
yes, my lord.
Yes. You were the person out there. Tell me,
Well,
why
here-
there are so many repetitions together?
Basically, my lord, I'm claiming contextual liability from the Tiva Autonomous Council, my lord. I have done some construction work allotted by the Tiva Autonomous Council.
Hmm.
They have made part payment, my lord. I have completed the work, but remaining balance they have not cleared, my lord, till date.
How will they clear when the original documents are before this court? These signatures are all whose? The president and all these things, annexes C, utilization certificate.
Yes.
If the originals are here, how is that these people going to do it? Tell me. Have you seen that? Okay, I'll do. Give it to him also. Let him also see. If the original documents are here, utilization certificate is here. Next, so the next page. Then,
Maybe-
why haven't you submitted the original one there? Or you have submitted for this court to decide? Tell me.
No, my lord, maybe these are duplicate, my lord. They have submitted the original one. Maybe this one, my lord,
Where is it written? It is duplicate.
has not been written there.
It's an inspection report.
Yes, ma'am.
Signed original. Then it's not duplicate. All these are original here. Certified that payment of so and so. These are all signatures. See, these are original signatures. All these files are here. It's the answer. Tell me, how can I help you?
My lord, maybe
Maybe what?
they have made two copies, my lord. One copy they have submitted and one copy they have kept with them, my lord. That is the reason, my lord. The original signature is there, my lord.
Understood. You may have made two copies.
Yes, ma'am.
Why will the inspection report be made two copies? And with original signature. These are not photocopies. These are not colored photocopies also. See the signature.
I have seen, my lord.
Then, see these signatures out here. These are all signatures.
Yes, ma'am.
Then, the originals are here.
This is the reason, my lord. Maybe they have prepared two copies with all original signature, my lord. One they have submitted with the.
Now, what do you want?
Well, only notice was issued, my lord, and my line of training is supposed to open the instruction whether I have completed the work or not.
Oh, what he can this be verified out here? Whether he stays or who stays? And if he has done it, then this court will direct payment.
Yes, well, if
You verify and make payment as per your contractual conditions.
Yes.
What was your contract
With my lord,
with them? How did you allow him to work?
my lord, that has been challenged, my lord, in a discussion, but eventually, my lord, that my lord, the process of granting, my lord, for contractual work to the by forming this construction committee,
Hmm.
that has been challenged in the High Court, my lord. In a writ
High Court,
petition.
this is also High Court.
Yes, my lord.
Then
That has been the petitioner who has challenged it has died, my lord. Eventually, that there was a stay order also, and then we recall the entire work allotted to the various construction committee.
then you
And
recall.
Thereafter, my lord, these 250 constructions work,
Hmm.
they were in verge of completion, my lord.
Hmm.
So this honorable court has modified the stay order and allowed us to go with this 250 construction work. And this bunch of writ petitioners
Ah.
are falls within that 250.
How much are the amounts in all the cases?
Less than 10 lakhs, my lord. There are different amounts.
in some cases, my lord, the balance amount is 3 lakhs, and in some cases, 6 lakhs. my lord.
So what to do? Pay pass similar orders like
Yes, my lord,
1/8.
yes, my lord, there is an order.
Yes, my lord. We will verify
Yes,
and
16, my lord.
if found eligible, my lord, we will
Uneligible as per the contract conditions. You had the contract? No.
With the.
How did you give it to them?
My lord, there is no contract as such, my lord, with the. Only the TAC, Tiwa Autonomous Council, forms the construction committee with respect to the constituent.
Then?
And they allot work to the construction.
In fact, my lord, the order of allotment, there is a.
So you have no objection after verification to make payment.
My lord, this is of 2018. My instruction is this is of 17-18, my lord. So we need to file the utilization certificate to the government for the next month. So we will verify if the work has been completed, my lord. We will make it.
Today petition ki kon ko? Kita.
In fact, my lord, in the order.
You have
of
a series, na? This is a
Yes, yes,
series.
yes.
How many matters?
Total,
My lord,
12
44. No, 44. 44 up to 44. My lord, from 32 to 44.
All are similar.
All are similar.
Construction works are different, my lord.
Different, but what is the different construction work? That passport is to bagi ki buda eki leki di. Similar order ko di. Ene ke di. Te baki kita file. Itu এনেকে অবস্থা দে মই এটা বনাই দিছো হা এনেকে বনাই দিম বাকি kita খালি construction worker to বনাই and more heard Mr. All you are appearing.
Yes, my lord.
Very good. You got everybody out there. Heard Mr. NJ Khatonia Dalalita. Yes, may itu kuri tupai. Heard Mr. NJ Khatonia, the Learned Counsel appearing on behalf of the petitioner. Mr.
S. Nyogi,
S. Nyogi appears on behalf of
all the respondents.
the
1 and 2.
respondent. Appears on behalf of the respondent, Tiwa Autonomous Council and its officials. The instant writ petition is filed by the petitioner challenging the inaction of the respondent authorities in releasing the dues to which the petitioner is entitled to upon completion of his work allotted to him by the construction committee of the respondent Tiwa Autonomous Council. The case of the petitioner herein that the petitioner was allotted the work of work of construction of Kala Srishti Kendra bracket Sabhaghar bracket close at Sarangkusi. The value of the work was rupees dash. It was 7 lakhs. Out of the total sanctioned amount of rupees 7 lakhs, an amount of rupees 4.20 lakhs was released as first installment. The remaining amount was to be released subject to production of MB vouchers, utilization certificate, completion certificate, and one photograph before start of the scheme, one photograph during work, and one photograph after completion of the scheme, with signboard duly signed by the president and the member secretary. The petitioner completed the work in a time-bound manner. Now, it is alleged that the petitioner had completed the work in a time-bound manner, and the petitioner submitted, and thereupon the petitioner submitted the final bill for release of the final installment accompanied by the utilization certificate, photographs of the work, as well as with the inspection report of the concerned junior engineer. In all cases, same.
Yes, madam. Yes, madam.
The petitioner, however, is agreed that in spite of submission of the necessary documents and completion of the work, the respondent authorities have not made payment to the petitioner of his entitlement. It was his or her, of the petitioner's entitlement. It is under such circumstances the instant writ petition has been filed. Mr. S. Nyogi, the learned counsel appearing on behalf of the respondent, submits that the construction committee of the Tua Autonomous Council is authorized to allot works, construction works up to an amount of rupees 10 lakhs.
Less than.
Up
Yes,
to
yes, madam.
up to an amount of rupees 10. There is no denial to the fact that the work in question was not allotted to the petitioners. The learned counsel, however, submits that the entitlement of the petitioner would be dependent upon further verification to be carried out by the respondent's authorities. Upon hearing the learned counsels for the parties and upon perusal of the materials on record, this court is of the opinion that the respondent authorities, being the state, is of the opinion that if the petitioner had completed the work in question, the petitioner would be entitled to the amounts as claimed. However, the said would require a verification on the part of the respondent authorities. This court, therefore, disposes of the instant writ petition with the direction upon the respondent authorities to verify as to whether the petitioner had completed the work in question as per the allotment of the work, and also as to whether the petitioner had submitted the requisite documents which is required for the purpose of releasing the amount claimed by the petitioner. This court, therefore, further directs that the respondent authorities, after verification, the respondent authorities that if upon verification it is found that the petitioner is entitled to, the respondent authorities shall pay to the petitioner the entitlement to the extent of the work completed by the petitioner. The said exercise be completed within 6 months from the date a certified copy of the instant order is served upon the respondent number 2.
Time being item 60.
But I took instructions, it will require another 15 days. Since, my lord, to be very honest, they said it will be credited salary account in 10 days. Before, my lord, safeguard.
We'll have it on 19th.
19.
Your lordship, another aspect, your lordship. Due to the pendency of the departmental proceeding, your lordship. I have been placed at gradation at serial number 10 in the gradation list. My juniors have been promoted and I am going to return on January, your lordship.
Mr. Mazumdar,
Already one.
Mr. Mazumdar, let us first deal with one
Yes, your
aspect.
lordship, one issue.
One
Let
issue.
me take-
Heard
the next
Mr. R. Mazumdar, the learned counsel appearing on behalf of the petitioner, and Mr. T. Gogoi appears on behalf of the respondent number 1, 2, and 3. Pursuant to the directions passed by this court on 24/5/2023, the learned standing counsel for the Forest Department have placed on record an order dated 13/6/2023, whereby the subsistence allowance of the petitioner for the period with effect from 1/6/2021 to 18/5/2022 was enhanced under the provisions of Rule 53 bracket 1 bracket Roman 2 bracket small a bracket Roman 1. It was small 1 Roman 2 or Roman 1 okay, small ID. Subject to the condition under sub-rule 2 of FR 53. You have submitted you are not working anywhere?
No, I am working. I already reinstated, working.
He's reinstated, my
Oh,
lord.
he's
Reinstated, I am working.
No. At that point of time, you were not working.
No.
Did you submit
Under
that
suspension.
certificate?
Your lordship,
Have you submitted that certificate that you were not working at that point of time?
reinstatement order is there.
Mr. Counsel, during subsistence, in order to get the subsistence allowance,
Your lord.
you are required to submit a certificate in terms with 53(2),
Yes.
saying that you are not working anywhere. Have you done
No,
that?
That is obviously there, your lord.
Have you done that?
Obviously done because I have.
Because if I do pass an order, then they will come up with another excuse. That is why I'm asking you.
It is only for some period, your lordship. Other before and after I have already got. So obviously I should.
Mazumdar, you are not understanding.
Lordship,
Okay.
on the next day, I will confirm it, your lord.
No. We should not leave that. Means this court,
Yeah.
Mr. Gogoi, the learned counsel for the said order is kept on record and marked with the letter X. Mr. Gogoi, the learned counsel for the Forest Department, therefore submits that some more time would be required for the purpose of disbursing the said amount, taking into account that a
Separate budgetary provision.
separate budgetary provision would be required for payment of the subsistence allowance. This court by the order dated 24/5/2023 had specifically directed the respondent authorities to pay the subsistence allowance to the petitioner for the said period within 3 weeks from the date of submission of the certified copy of the order. The said payment, however, has not been done. Mr. Gogoi, the learned counsel for the Forest Department, further upon instruction submits that the said amount would be credited to the account of the petitioner within 15 days from today. List the matter again on 19th of July 2023, on which date the learned counsel for the Forest Department shall submit the compliance to the order dated 24/5/2023. The learned counsel for the Forest Department further has apprised this court by another communication issued by the Secretary to the Government of Assam Environment and Forest Department that the departmental proceedings against the petitioner is under process inasmuch as the inquiry officer has already been appointed. The said communication is kept on record and marked with the letter Y. Now tell me, have you given the memorandum of charge to him?
So forth.
My lord,
And I have replied.
You've got that?
he has got
I-
the reply.
I secured.
He replied. Okay. What about the presenting officer?
That I'll see.
Don't do it, then later on he comes up with that plea.
Your lordship, I am placing one judgment within 1 year. Supreme Court. There may be kept
List the
open.
matter accordingly on 9. Not
Noted,
as it is.
Item 45.
That is as per the CVC thing, na? That judgment, what was the name of the judgment?
Devnath Bali versus Registrar Delhi High Court.
Yes, Ayurvedic. Oh, that judgment, there is a recent Supreme Court judgment in your favor.
In fact, now my lord, the position is altered.
Ah,
Today we got a favorable order in court number 5. Same Ayurvedic doctors, they wanted that their age of superannuation should be similar to the allopathic doctors. That is
that
65
Supreme
years.
Court judgment.
That's state of Gujarat versus some.
Eh?
Now, my lord, here, my lord, so far as the order is concerned, it was, my lord, passed relying upon a Uttarakhand judgment, my lord, which was subsequently allowed in the apex court. And, my lord, this order was passed that we'll have, my lord, the allopathic doctors and Ayurvedic doctors are in parity. And we should give the same, my lord, salary to both.
Which one?
Page 80, lordship may
Oh, this one, yeah.
Yes. Para 16.
Ah.
Here, my lord, the effective date has been given as 18/12/2018.
Uh.
Now, in compliance of this honorable court's order, lordship will see page 81, next page. We have issued an order. That NHM has issued an order dated 21/10/2022. Lordship will see, my lord, the chart. Medical officer Ayush. There, my lord, at that point of time, their fixed remuneration was 30,500. It has been made, my lord, at par with the allopathic doctors, that is 40,000 per month from 18/12/2018 to 31/3/2019. And, my lord, 50,000 per month from 1/4/2019 because it was revised on 1/4/2019. Here, what has happened is, my lord, almost, my lord, most of the members of the petitioners association, my lord, through the information of the authorities, they have got the benefit. But, my lord, few, my lord, Ayurvedic doctors, say, my lord, one who has joined in 2007, by getting the remuneration and, my lord, advance increment every year, their salary on, my lord, 18/12/2018 as Ayurvedic doctors were more than 40,000. So we cannot decrease it. So we allowed them to continue with that. And, my lord, whatever revision comes to the allopathic doctors in future, they will get that, my lord. Likewise, like, my lord, the petitioner number 2, my lord, who is a petitioner number 2 herein, he is the secretary of the association, I suppose. He was drawing salary of 61,769 as on date. And on that day in 2018, it was more than 40,000. So we cannot, my lord, bring it down. Now they are claiming that, my lord, it should be given at that stage, some area will have to be added. My lord, if this is an individual, my lord, grievance of the petitioner, some of the members of the petitioner association, they should approach the authority, my lord. These are disputed facts. They will consider, they will sit together and it should be resolved. Otherwise, majority of the members, they've got the benefit. We have given it, man.
No, madam. No, madam.
Well, the lordship will see the pay slip of the petitioner number 2 and 3, my lord. They are the main, my lord. Higher authorities.
Lordship was directed to file an affidavit, man. Let whatever he's saying.
That I can file, my lord. I have got a note, my lord. I have talked with them, my lord.
Let him
They
file the
said that,
affidavit,
my lord,
my
At least they let them approach the authority. Without approaching them, they have directly approached the honorable court, challenging that compliance order. I leave it to Lord, either lordship can dispose it of directing them to approach, or will file one affidavit indicating all this fact.
There's a direction from this court to file an affidavit, my last time.
I will file it, my lord.
Then I will file the reply of that. How the balance is, because in 2012-13, the salary was equal, my lord. Later on, they have been gone to 40,000, then 50,000.
My lord,
We are remaining 30,000.
2018, my lord, as per the order of this honorable.
No, but the thing has come from there, my lord. So in 2018, my lord, on the day, they were having getting some 90,000 something like that.
And my lord, one
And
more.
we are getting.
Lordship may kindly see page 84 for a moment, my lord. Page 80, my lord, the last portion of it has been quoted, my lord, of the Honorable Apex Court of Judgment. There, while dismissing the SLP of the, my lord, Uttarakhand government, my lord, the Honorable Supreme Court gave a liberty to the authorities to prefer a review petition before the High Court. If at all, my lord, that judgment of Uttarakhand has been reviewed now, along with this judgment that has come into force, my lord, we can also prefer a review against this order now. Because it's a settled position of the law as on that they are not in parity. Specifically, my lord, it has been reviewed. We can prefer otherwise. So let it be after vacation. Let me, my lord, see whether what has happened to Uttarakhand. Yes. If they have preferred in review now, it has been reviewed. Of course, then we can also go for review, my lord. Because liberty was given by the Apex Court to them in 2018.
Did you go
Their
in
judgment also, my lord.
but did you go in it?
My lord, the Supreme Court judgment was there at that point of time in 18, my lord. Just day before the date of hearing, that judgment came, and today's case, my lord,
Dismissal of a SLP does not make it. It was a dismissal of an SLP.
yes. Thereafter, in the same order, liberty was given that you should approach
Understood,
for
but
review.
SLP was dismissed.
Yes.
Obviously,
So-
it was in effect, it was an order of the Uttarakhand High
Yes.
Court.
Yes, my lord.
That is why we have not gone for it.
Then why didn't you file an appeal? Why do you have to file a review?
No,
can file
SLP
a
was by the state. SLP was by the state.
Understood. You should file an appeal here if you agree. You have not done. How can you file a review now?
No, my lord, if that order has been reviewed now, my lord, in Uttarakhand, we will have to check. My lord. In that case, my lord, probably after vacation.
When
my
we
lord,
were studying law, there was a judgment of election dharamcha. That is a very important judgment, wherein it says that the change of the law, change of a decision, or whatever may be of the Supreme Court, does not give you a right later on to pursue that limited.
it will have a prospective effect.
This is ended for them. Whatever has ended is ended for you. Commission may not be good. Anyway, the cost of 25,000.
No, my lord, here, my lord, I have otherwise prepared. I am ready for hearing also. I can place the fact. I can place the, my lord, hypothetical examples, my lord. Why, my lord, we have already complied. Everything is there in my report.
So you don't want to file it.
If, my lord, he is insisting that we
No,
can,
he
so that
won't.
he can revert.
You will go on. No, you will go on the doctrine of non-private.
Yes,
You will go on the doctrine of non-private. You have not denied to it. We will only see on the basis that each whatever he has said is your limited scope of argument is
We will definitely file on affidavit.
25,000.
But that part, my lord,
Because the
otherwise,
direction notice we have put. Your
Yeah,
president of your bar association said it, we should impose costs so that goes to the benevolent lawyers benevolent fund. So we impose the cost of 25,000.
no, otherwise, my lord, I am ready
It
for
will be
hearing.
good for the people. Okay,
Otherwise, I am ready for hearing.
okay, we will hear it. But your limited is only to that effect. You can only show, only on the point of law, not on the fact. Yes. Let us hear it.
The fact part, my lord, otherwise it is clear, my lord.
No, only
But
on the
they-
facts.
No, on that
No
point,
fact. on
they
no-
will have to show that, my lord, who are the persons who have not, otherwise, how can we, my lord, we can repart, my. They have come as an association. Earlier, my lord, all the, my lord, members, my lord, they were not getting the same pay scale. Now, my lord, they are getting the same remuneration after the honorable court's order. Accordingly, we have complied. They are, my lord, agreed by only one line.
Which
Lordship
line?
will see, my lord, the page 81. In the up, just below the, my lord, table. In
Yes.
case of drawing lesser remuneration per month.
Wait.
In the, my lord, below the table, the existing medical Ayurvedic Ayur doctors under NSM Assam are hereby eligible to draw the revised initial remuneration for the corresponding period as above from so and so. In case of drawing lesser remuneration per month.
So they say that if it is higher than that,
No, they are not saying. Our contention is this, my lord. On 18/12/2018, if any Ayurvedic doctor he was drawing more than 40,000, we cannot bring him down, my lord, to 40,000. Supposingly, my lord, someone is getting 50,000 because of the annual increment added to his, my lord, remuneration. So we cannot bring it down. But we have assured that whenever there is a revision or increment is increased in
no,
case
why,
of
why the petitioner agree?
that's why, my lord, they will have to, my lord, place that, my lord. They will have to show that out of the members, my lord, these are the 1 or 2 persons who have not got. Otherwise, my lord, to my information, majority have got the relief.
Yes,
They are
Mr. Sinha, what
satisfied.
is your case?
Yes, my lord, whatever, my lord, during 2012 and 13, the basic of this MBBS doctor were equal 30,500, both Ayurvedic and allopathic. Then later on, after 13 and 14, their basic was enhanced to 40,000, and our basic was remained same as 30,500. Then while coming down in the 2019, their basic was enhanced to 50,000, other than the allowance. So we were remained same as 30,500. Therefore, those officers, Ayurvedic officers, who were receiving 30,500, by adding their annual increment in the year 2019, they have almost, most of them have crossed 50,000 total remuneration, not the basic mind, but the total remuneration of those MBBS who were receiving 40,000 in the year 2013-14. Later on, they have received 50,000. They have gone more than 1 lakh. Then here the direction is their salary will be at par. So we are not claiming that we should be given the salary.
So now you are asking for pay parity.
Yes, pay parity, man. Pay parity. So therefore, in the 2018, man, if it is
Pay parity, lord, you will see, my lord,
Where is the judgment of the Supreme Court?
But that, of course, my lord, I have not got that. But lord, you will see pay.
No, the judgment where there cannot be a pay parity.
For that part, my lord.
Where is it?
But that I have not got, my lord.
This
But
is
my
the-
lord, you
where
will
the
see,
Supreme
no.
Court holds that pay parity cannot happen
Yes.
between MBBS and I.
But that part, my lord, is very clear, my lord. It's not same, my lord.
So we go by the Supreme Court judgment.
My lord, it is State of Gujarat versus Dr. P.A. Bhatt. P.A.
Yeah.
On 26 April 2023, the order was passed by the Apex Court.
I've read that judgment.
Yes. But lord, you may see, apart from that, page 80 for a moment, para 16 of the judgment, my lord, of this honorable court.
I've read it to you.
It is very categorically, it has been stated that from 18/12/2018, now they are bringing in 2014. They will have to go for a review of this order in that case. Honorable Court said that even though you have preferred the writ petition, way back in 2018, no, your claim is from 2014, but from the date of filing of the writ petition, you will get the benefit. So 2014, 13, whatever was their disparity, that has been decided in 2018 and date has been fixed that from 18/12/2018, it will have to be at par with the allopathic doctor. So that is the parity.
But Mr. P. Sinha, the learned counsel appearing on behalf of the petitioner, and Mr. B.B. Gogoi appears on behalf of the NH. The learned counsel, the case of the petitioner. So I dispose it of.
Well, we will verify if they have got any issues otherwise also, my lord. we have nothing to, my lord, we don't want to deprive them, but my lord, as per our instruction, we have done everything to give them, my lord, whatever benefit is due pursuant to the earlier order of the honorable. Left,
So you say the 2014 issue, you can't rack it up now
now, my lord, because there is a power of
the
the honorable.
judgment has been given from 2008.
If they can show that from 1812-2018, somebody is deprived, my lord, we are not following, they can immediately represent individually, my lord, not as a state. We will look at that.
You got it. But the case of the petitioner herein, the petitioner herein is an association of Ayurvedic doctors working in the National Health Mission Assam. The petitioner number 2 is the president of the said association, and the petitioner number 3 is the general secretary of the said association. By way of the instant with petition, the petitioner have assailed the order dated 21/10/2022, whereby the mission director, National Health Mission Assam, had, in compliance to the order, had, in terms with the order dated 29/3/2022, passed in WPC number 8759/2018, had revised the salary remuneration of the medical officer bracket IU from rupees 30,500 per month to rupees 40,000 per month during the period from 18/12/2018 to 30/3/2019, and rupees 50,000 per month with effect from 1/4/2019. In the same order, it was also mentioned that the existing medical officer IU doctors under NHM Assam would be eligible to draw the revised initial remuneration for a corresponding period in case of drawing lesser remuneration per month. It is further relevant to take note of that the petitioners, by way of the instant with petition, have also sought for a mandamus directing the respondent authorities to make salary of the medical officer IUR at par with medical officer allopathic under NHM Assam with effect from 18/12/2018 and from April 2019 onwards. Both allopathic and Ayurvedic are working under NHM.
Under NHM. It is a medical officer MBBS, not allopathic. It will be a medical officer MBBS, not allopathic. There is a designation.
Mr. It is relevant to take note of. In order to decide the controversy raised in the instant writ petition, it is relevant to take note of that in WPC number 8759/2018, the grievances of the petitioner herein, who were also the petitioners in the said writ proceeding, is that while the National Health Mission had engaged allopathic and Ayurvedic doctors under the NHM on contract basis, the fixed pay given to the allopathic doctors is higher than that given to the Ayurvedic doctors. The courted bench of this court by judgment and order dated 29/3/2022 taking into account a judgment passed by the division bench of the Uttarakhand High Court as well as the state of Assam having taken a conscious decision to give the same scale of pay to Ayurvedic doctors and allopathic doctors working in the health department, directed the respondents, that is the NHM, NHM was there, na?
Yes,
NHM.
Directed the respondents in the said writ proceedings to pay and release the salary to the petitioners therein at par with the allopathic medical officers of NHM Assam with effect from the date of filing of the writ petition, that is 18/12/2018. It is in pursuance to the said order, said judgment dated dated 29/3/2022. The impugned communication was issued. Mr. B. Gugoi, the learned counsel appearing on behalf of the petitioner, a respondent, NHM submits. What is that judgment?
Yes. It is the state of Gujarat versus Dr. P.A. Bhatt.
Wait. P.L. Bhatt.
P.A.
E.
A. Bhatt. B.H.A.T.T.
Huh?
Bhatt. B.H.A.T.T.
P.A.T.T.
Bhatt.
ये लिख रहे the learned Mr. P. Gugoi. Huh? Submit. Had submitted.
Para 22 was the issue. 24.
That in a recent judgment by the Supreme Court in the case of State of Gujarat and others versus Dr. P.A. Bhatt and others, reported in 2023 SCC Online SC 503.
Para 54.
Had decided, had taken up an issue as to whether had decided the issue as to whether allopathy doctor and doctor of indigenous medicine can be said to be performing inverted comma equal work inverted comma close, so to be entitled to equal pay. The learned counsel, Mr. B. Gogoi, referring to paragraph number 42, 43, and 44, submitted that taking into account the submitted that the Supreme Court had categorically observed that the duties to be performed by the allopathy doctor and by an Ayurveda doctor are completely different and distinct. The learned counsel therefore submitted that the Supreme Court in the case in the said judgment therefore observed that even while recognizing the importance of Ayurveda doctors and the need to promote alternative indigenous system of medicine, observe that both categories of doctors are certainly not performing equal work to be entitled to equal pay. The learned counsel for the respondent therefore submitted that the second prayer, that the relief enumerated as B, small b, cannot be granted in view of the judgment of the Supreme Court in P.A. Bhatt, Dr. P.A. Bhatt Supra. The learned counsel further submitted that the impugn order dated 21/10/2022 was issued taking into account the respective salaries at that relevant point of time. However, at that relevant point of time, there were certain doctors from Ayurveda, Ayurvedic doctors, some medical officers, Ayur. For example, the petitioner number 2 and 3 herein whose salary was higher than 40,000 as on 18/12/2018. And it is under such circumstances to protect them it has been mentioned that only those doctors who were getting lesser remuneration than the revised remuneration would be entitled to the benefit thereof. The learned counsel further submitted that after 18/12/2019, what did you say? There is no further discrepancy. What is that?
Yes, there is no further discrepancy after 18/12/2018.
After further submitted that after 18/12/2018, there is no further discrepancy.
And my lord, we have also given, my lord, the revised scale from 1/4/2019. There is 50,000. It was given.
And the revised scale
Has been
of
notified.
rupees 50,000 per month
Yes.
have been duly given,
Notified, man.
have been
Yes,
duly,
yes.
no, it is already notified.
Notified, man.
You are
It
giving
was
or not?
notified is on 2022.
Ah.
Area they will get, my lord. At a lot they will get. Notified.
Have
They will
already
get.
been notified with effect from 1/4/2019, and the areas would be duly paid to those persons who are entitled to. The learned counsel therefore submitted, for the NHM therefore submitted, that it may be one or two persons, it may be some members of the petitioner, as petitioner number 1 association, who may not have received the entitlement in terms with the order dated 21/10/2022. And as such, they would be they can represent it before the said authorities.
One more aspect, my lord. They are claiming, my lord, that they should get parity from 13 and 14. Since, my lord, their effective date has been given.
Enough. What more?
Here, my lord, the petitioner did not get anything, my lord, by this order. He was 40.
On the other hand, Mr. B. Sinha, the learned counsel appearing on behalf of the petitioner, had submitted that in the year 2013-14, the remuneration of allopathic doctors as well as IU doctors were the same.
There is 12 and 13.
12 to
2012 and dash 13. And from 2013, 14.
2012, 13.
Yeah.
it was same. However, subsequently, there was an increase in the salary remuneration of the allopathic doctors and the remuneration of the IU doctors remains stagnant.
And one more just submission.
By the time the writ petition, that is WPC number 8759/2018 was disposed of, the remuneration of the allopathic doctors was much higher than the rate as fixed in the order dated 21/10/2022. The amount which has, however, been taken into account in respect to the petitioner number 2 and 3 is based upon the increments and not on the basis of the remuneration.
Yeah.
That is your submission.
Yes. And one more explanation.
Yes.
The MOIU of Department of Health, my lord, this is the government department. They are equal pay scale. They are maintaining that.
Where?
This is MOIU of this is the Department of Family and Health and Family Welfare.
Mm.
And the MOMBBS of Department of Family and equal my lord, they are getting pay scale. Everything is equal, everything is identical.
The learned counsel further submitted that a medical officer IUR and a medical officer allopathic in the government of Assam, Department of Health and Family Welfare, is however receiving the same amount. I have heard the learned counsels for the parties and given my anxious consideration to the matter. From the judgment passed by the Supreme Court in the case of P.A. Bhatt, Dr. P.A. Bhatt Supra, it has been categorically mentioned that the medical officers allocate mentioned that the Ayurvedic doctors and the allopathic doctors discharge diverse functions and as such would not be entitled to the equal per and a diverse function and perform and are not performing equal work and as such would not be entitled to equal pay. This issue, the issue, therefore, pertaining to grant on the principle of equal pay for equal work, therefore stands concluded in view of the judgment of the Supreme Court in Dr. P.A. Bhatt. As regards the contention relating to the challenge to the order dated 21/10/2022, whereby the benefit of the revised structure have been given only to cases who were drawing lesser remuneration per month. And the basis and taking into account the submission of Mr. B. Gogoi that the said was done so in order to protect those Ayurved, those medical officer Ayu, so that they do not get lesser the amount than what has been revised. This court therefore is of the opinion that the question of interference with the order dated 21/10/2022 is therefore not called for. Be that as it may, this court is also of the opinion that if the members of the petitioner association is not getting the benefits in terms with the order dated 21/10/2022, the members of the petitioner association should and would be entitled to, the members may represent, would be at liberty to represent before the respondent number 3, who shall, taking into account the order dated 21/10/2022, grant the benefits as given therein. With the above, the petition stands disposed.
Well, respondent number 2. Respondent number 2. Respondent 2. Who shall thereafter you considering, my lord, only will see, my lord, if he is entitled, will give. If they represent that, right modification. We'll consider and thereafter if entitled will give.
You have already given. You have already revised. If he has not got it, no, if he has not got it, what is this consideration? If you have not got it, then we will give you.
Yes, not yes. Obliged, ma'am. Obliged.
Hello. Yes, any urgent, no urgent? Yes, what is there?
Item, then
Huh?
any other date after petition item, then
69?
any other.
Okay, list of the vacation.
date.